Ai kāti tēnā tātou, tēnā koutou e whakarongo mai nā. Tuatahi me ino i tātou. E te ariki ka tuku ngā whakamoe me te ki a koe nā ura ngā mea katoa. Nā wano i ārai te huarahi ki a taipai mai mātou tēnei whakamininga. I rungi te kaupapa kei mo i a mātou. Tono iho mai te tō mai rangi o tō ata whai ki rungi a mātou i tēnei rangi. Tēnei au punanga e inoi atu ki a koe e te ariki, kaupareti atu te kino, i a mātou, i o mātou whānau, i o mātou kāinga, i o mātou marae. Pai heretia mātou, i tau rangi maari a mutungo kore, ka inoi atu ki a koe i rungi te ingo tōu tama a iu karaiti, ake tūna atu, āmene.
Aroa mai, ko te timatanga o te whakaaro nui, ko te wehi ke iho o tō tātou matunu i te rangi. Nā reira tēnei rā te whakamihia tiki a koe e karai Monti, e tuku atuna te reo whakawhetai, hako mai mi tiki tō tātou kaihanga. Kia koutou hoki kua hono mai runga i te ipurangi, nau mai, whakauru mai, ki roto i tēnei noho a tātou. E maumaharatanga ki o tātou ai tua maha kua takātu ki tua te ārai. E ki nei te kōruko tangi hia rātou ko mihia, ko poroporo aki tia. Nā reira mai me ki ko ea. E mihia nara ki te mana whenua o roto tēnei rohe o tia oa, o tō rangatira, me te tini o koutou e noho kanei o koutou wā kāinga. E haere tuna na ngā mihi ki tēnā o koutou maunga hoki, o koutou awa, o koutou wai, ngā whenua papatua nuku. Nei rā te whakamihia ki a rātou. Ore koutou e kūmea kene weni mihi ki a rohona e whakataumania koutou ki roto i tēnei noho a tātou, i tēnei rā, nā reira huri no roto i tō tātou noho i roto i te kōtine, roto i o koutou rohe te o Aotearoa o whānui, tēnā koutou, kia ora tātou.
Tēnā koutou, e tautoko ana au ngā mihi kia koutou, o tira ki a koe te kaiwhakarite o te rā, Dr. Monti, nei rā te mihi ki a koe, kia ora ki a koe, Kevin. Kia koutou katoa i runga i te ipurangi, nei rā te mihi kia koutou, mai te rōpū whakamana i te tiriti. Let's start. I just want to begin by introducing again the panel who are sitting on this inquiry. First of all, there's Kevin Prime, Ngāti Hine Ngāpuhi, who just spoke. His background includes over 20 years with the Environment Court as a commissioner. Environmental Commissioner, and we're very lucky to have him on this tribunal. We have Mr. Derek Fox online, all the way from Rarotonga. Ngāti Pro rongo mai wahine. His background includes multiple positions in the media, and famously he was one of the pioneers of Te Karere, the first Māori program in Te Reo Māori. Dr. Grant Phillipson, again online from Invercargill. Historian, policy analyst, and writer extraordinaire. He's a well-loved member of the Waitangi Tribunal. Then we have Puru Kapua Te Arawa, lawyer, litigator, and leader of Wahine Māori. Emeritus Professor David Williams, distinguished legal scholar, author, and teacher at the end of this table. And myself, Karen Fox, Ngāti Pro Rongo Whakata. We all greet you and acknowledge your presence here today. Oh, and I just forgot my colleague from Ngāti Pro, Dr. Monty Suter, who just reminded me he's here. Of course he's here, he did karakia. I acknowledged you in Māori. So that's the panel. We also are supported today, you won't be able to see them, but we have our staff with us here today from registry, facilitation, And from report writing, we have Don Rowe, Heavenly Lee Teofilo, Meg Russell, Sophie Clark and Judith Pryor present with us today. And online we have Paiheke Magavi, who's translating. If you need to hear the translator, he's online. And Alan Doyle is our technician today. So if you know any of their numbers, feel free to contact them if you're having trouble with either the technology or any of the documents, in the sense that you need them emailed to you. They'll be able to provide them. So that's us, and now I'd like to take appearances of council, please. And if you could tell me who you're representing by name, not just by Y numbers.
Tēnā koe, Your Honour. Tēnā koe, panel. Council's name is Mason, and I appear along with my learned colleague, Mr. Johnson. We act for a number of claimants in this hearing. The first one is Jane Rooker on behalf of the Waitaha Executive Grandmother Council. Y3316 is her claim number. Mr. Daniel Watson and Mr. Rooker on behalf of the Waitaha Grandfather Council, and their claim number is Y3343. Ms. Api Mack, and she is on behalf of Ngāti Awa Tai Kapiti, and her claim number is Y3321. Mrs. Ruiha Collier, Rihari Dargaville, and Joseph Kingi on behalf of themselves and Ngāpui Nuitonu, and their claim number is Y3320. Ms. Moirangi Portiki, who is the chair of Ngāti Whakawe Runanga, and they're in Maketu, and her number is Y3318. And Mr. Sailor Morgan and Francis Galton, who have a claim on behalf of their Ngāti Rua Mahue Hapu, and they are based in Whangaroa, and their claim number is Y3317. Thank you, Your Honour.
Mr. Sharp.
Tēnā koutou te raupa whakamane I te tiriti o Waitangi, ko Michael Sharper hau. I appear for Y3329, which is a claim on behalf of Ngāti Mirawai Hapu. Tēnā koutou.
Kia ora, Ms. Sykes.
Morena I te kai whakawā koutou hoki o te rōpū whakamana I te triti. Ka tukuna te rākau kia Ms. Te Hira, nāna I whakamohio kia koutou ko wai ngā kai kreme I muia koutou I te rānei. Kia ora.
Kia ora.
Tēnā koutou katoa. Tēnā koe te kai whakarite o tērā tātou kua karapine pine mai nei tēnei ata. Ko tā maua ko Ms. Sykes te whakakanohi I te kreme wai tahi iwa whā me te tahi rua. He kreme tērā nā Colin Skerritt White, Timi Te Pō Hohepa me te Tariki Derek Morehu, mo te hapu o Ngāti Tirangi Unora me te iwi whānui o Ngāti Pikiao. Kei te whakakanohi o ki maua I te kreme wai toru whā rua. He kreme tērā nā Pita Tipene, Moana Maniawoto, Tākuta George Laking, Tākuta Veronica Tāwhai, Donna Kerridge, me India Logan Riley, mo te rōpū ngā toki whakarururanga. Kei konei hoki maua e māngai kōrero ana mō ngā interested parties o wai rua iwa whā, he kreme tērā nā whā dona awa tere huata. O tira te kreme wai rua waru whitu rua, he kreme tērā nā Tākuta Leonie Pihama, Angeline Greensill, Miriana Pittman, Hilda Hawkyard, Harawira, me Tiringa Hui Ahata.
Kia ora.
Tēnā tātou.
Kia ora. Dr. Gilling.
Tēnā koe te kai whakawā, me te rōpū whakamane Tiriti o Waitangi. Tēnā koutou. May it please the Tribunal, Council's name is Gilling, and I appear today with my learned colleague, Mr. Henry Fobister. we appear on behalf of 3 interested parties. Y58, claimed by Patricia Taurua and Robin Taurua on behalf of Ngā Hapu o Whangaroa. Y1312, claimed by the late Karanga Poreira and Tarzan Hori and their still living children, Whahenimoa Poreira and William Hori, on behalf of themselves and the descendants of Whakaki and Te Hapu o Ngāti Kāwau, also in Rangaroa. And Y1684, acclaimed by Doreen Puru, Anna Portery, and Emma Torkler, and the late Louis Katani, on behalf of themselves and 3 other hapu of Whangaroa. That was Y1684. Please, the tribunal.
Thank you. Te Karu or Te Karu Brown?
Pēnā koe te kai whakawā, mei hoki koutou ki whakamane i te tiriti o Waitangi. Ko Brown tēnei e whakatinana nei i te tari o NR Lawyers ki raro i te maru o Miss Ngāpo. E konei hoki ki tō kitaha Miss Ngāpo. Toko toru wa mātou nei kaikireme ki tēnei o ngā paki rehua, o Wai Toru Toru Tahi Iwa, Miss Dali Paki. Tokoroa hoki ngā kaikireme whaipanga ki tēnei o ngā paki rehua, ko Wai Toru Toru Tahi Whā, Wai Ameripeka Raukawa Tei, rao ko Wai Toru Toru Kore, Tākuta Rāpata Wiri. E te kai whakawā me tō whakaitanga, ka mātakitaki māua tahi i tēnei o ngā paki rehua mai runga i te live stream.
Kei te pai.
O tira, tēnā koutou.
Kei te pai. Ms. Cassidy?
Tēnā koe te kai whakawā. Tēnā koutou ngā mema o te roku whakamana i te tiriti o Waitangi. Ko Miss Cassidy tōku ingoa, kei konei hau mō te kireme Y3351, he kireme Lady Tiriti Moxon. Nō reira, tēnei te mihi kia koutou.
Kia ora. Emma Jackson and Marka Charrington?
Tēnā koe te kai whakawā. O tira kia koutou ngā memo o te traipuna rei e tautoko ana hau ngā mihi kua mihi i tēnei ata. Ko Miss Charrington tēnei, kei konei māua ko Miss Jackson, no te tari o tūkau law e whakakanohi ana māua i ngā kreme e rua, ko Y682 te runanga o Ngāti Hine, me Y14641546 te kapotai. Kei konei hoki a Miss Coates i te ata nei, nō reira tēnā koutou katoa.
Kia ora, I can see her online. We won't be long, we'll get through this list first. Mr. Lambert.
Tēnā koe te kai whakawā matua, me ngā rangatira whaimane i runga te tepu o te traibunara, tēnā koutou katoa. Council's name is Lambert, appearing today with my learned colleague, Mr. Alexander, appearing today for Y2214, a claim on behalf of Professor Margaret Mitu, on behalf of Te Runanga a Iwi o Ngāti Kahu Charitable Trust, the Iwi of Ngāti Kahu and herself, Your Honour, as an interested party.
Thank you. Ms. Peters?
Tēnā koe te kai whakawā matua o te rā koutou katoa e noho ana ki te pai o tēnei rōpū whakamana i te tiriti o Waitangi. Ko Ms. Peters tēnei, kei konei māua ko Ms. Herewini, no te tari o Kaupare Law. E whakakanohi ana māua i ngā kireme e rua. Tuatahi he kireme na Whanora Rameka ma te runanga o Ngāti Rehia, mo te hapu o Ngāti Rehia. Ko Wai tahi toru whātahi me Wai toru kore whitu whitu. Ngā nama mo tērā kireme. Tuarua he kireme na umuhuri ma te haere, Pataraina nuku kepa, rātou ko Nepia Ranapia, mā rātou anō me rātou tūranga hei tarahiti mo te haupapa ko Hatu Trust, ko Wai toru toru whitu whā tā rātou nama, tēnā rā koutou katoa.
Kia ora. Emma Jackson?
Yeah, no good thing here. I've introduced Miss Jackson with us.
Oh, very good. Thank you. Ms. Johns, Tamaki Legal.
Tēnā koe te kai whakawā. Luke, Redwater appearing on behalf of Tamaki Legal with my learned colleagues, Ms. Tumai and Ms. Johns. Ma'am, I'm just aware we have 17 interested parties. Do you want me to read them all out?
Yes, we need to know who they all are to make sure that we've got the list right.
Okay, thanks, Mum. So first, Jasmine Cotter-Williams, on behalf of her whānau and Ngāti Taimana Waiti Iwi, Y2063. Stephanie August, for and on behalf of the late Robert Charles William James Farah and her whānau, Y1396. Robert Gable, for and on behalf of Ngāti Tara and Ngāti Kahu, Y1886. April Grace, for and on behalf of her whānau, Ngā Wahapu o Te Raroa, Ngāti Whātua and Ngāpui Nui Tonu, Y2206. Annette Hale, for and on behalf of the Wikotu whānau of Te Upo Kōrihi, Y2743. Tienga Harris and Lee Harris, for and on behalf of the Wiremu Himi Harris and Meri Otini whānau, and on behalf of members of Ngāti Rangi, Ngāti Here, Ngāti Tūpoto, Ngāti Hoha Tōko, Ngāti Kōpuru, Te Raroa, and Te Uniuku Y1531. Tasilofa Hurama, for and on behalf of the Hurama whānau and members of Ngāti Unone and Ngāti Tuatahi of Ngāpui, Y2890. Te Urunga, Evelyn Aroha Kiriopa, for and on behalf of the Kiriopa whānau and members of Te Ihi Ngārangi Hapu of Ngāti Maniapoto, Y762. Richard Nathan, for and on behalf of Mangakiha Hapu Claims Collective, Y861. Diane Marie Paiko, for and on behalf of whānau members of Ngāti Onuku, Ngāti Hoa, Ngāti Pawa, Ngāti Mahuta, Ngāti Tiata, and Ngāti Whātua, Y3131. John Pickery, for and on behalf of the descendants of Hone Karihina and members of the Hapu of Te Uri o Hau and Ngāti Torihina, Y2394. Ruben Taipari Porter, for and on behalf of the Hapu of Ahipara, Y1968. Audrey Okaroa Rogers, for and on behalf of her whānau and members of Ngāti Kōhereki, 2869. Jane Stevens, for and on behalf of her whānau and Ngāi Tahu Iwi, Y2671. Violet Eva Walker, for and on behalf of her whānau and members of Ngāti Rangi o Waipu ki Tāwhai and Ngāti Kahu ki Whangaroa, Y2382. Kahura James Watani and Elizabeth Watani, for and on behalf of Ngāti Tūkoko and Ngāti Moi of Rangatane me Ngāti Kāngungu, Y2778. And Michael Williams and Jessica Williams, for and on behalf of their whānau and members of Ngāti Upango Hapu of Ngāpui, Y2838. And those are our interested parties, Mum.
Thank you, well done. Ms. Chestnut?
Tēnei te kai whakawā, o tira tēnā koutou ngā me Māori rōpū whakamana i te tiriti o Waitangi, ko Ms. Chestnut ahau. I am appearing for Te Rōpū Wāhine Tuku I Te Ora, Y2959, who are an interested party in this proceeding. Tēnā koe.
And finally, we should have Lyle Swanson from Woodward Law. Are they online? No. And then, of course, we have for the Crown Mr. Allen and Mr. Ewing.
Mr. Ewing, Ma'am, that's right. Tēnā koe kai whakawā, tēnā koe panel.
Tēnā kōrua, welcome. And you've got Mr. Chandra behind you?
Yes, we have Mr. Chana seated directly behind me, Ma'am. and he's supported today by Ms. Young from the Ministry. She's the other person in the room with us.
Thank you. Good to have you here. All right, let's start with Ms. Coates and Tuko Law. Ms. Charrington.
Yes, tēnā nō koe te kaiwhakawa. Yes, we have Miss Natalie Coates online. I can see her there. And as the tribunal is aware, Ms. Coates has filed 2 briefs of evidence in this inquiry. And for the purposes of the hearing today, she will be speaking to her second brief of evidence, which is at appellation numbers A6D and A6E. So atu I tērā, I will just pass it back to you, Your Honour, and just commence with questioning. Unless you'd like.
When would you like to deal with your submissions?
Oh, apologies, Your Honour. I hadn't realised there was time for opening submissions. I thought we were just moving straight.
I need to let the people know who are watching what it is that you've said. If you could just give a quick summary, and then maybe Ms. Coates can think about the major points that she'd like to highlight in a 5-minute presentation.
Yes, Your Honour. 1 second, I'll just pull up my opening submissions.
And I should note for everybody listening, the media through various outlets want to have access to the live stream, and I've granted that unless anyone has any objection. There being no objection, then we'll proceed.
Yes, Your Honour. So my opening submissions are at appellation number 3.3.37. And I'll just speak to them briefly, Your Honour. As I suggested, I haven't prepared any oral submissions to complement these today. However, the general submission and the starting point that we make in our opening submissions is the issues that are being traversed today in the inquiry. And those start with the tribunal's issues as to whether the Crown's decisions regarding the Treaty Principles Bill since the release of Ngā Mātāpono are consistent with the Treaty of Waitangi and its principles. And then also what prejudice to Māori, if any, will arise if the amended treaty principles per the Crown's Treaty Principles Bill policy since the release of Ngā Mātāpono are enacted. And those are listed at 1.1 and of course in your directions. And our first and preliminary submission today is that the tribunal is not tasked today with finding whether there has been a new breach of Te Tiriti in this inquiry. Our submission is that that has been found. What we submit is that the cabinet materials submitted filed by the Crown, they contribute to the conversation around the exacerbation of that breach that exists and the Crown decisions that have been made since Ngā Mātāpono, but also before Ngā Mātāpono, and that Ngā Mātāpono was released on the 16th of August, if I'm correct, and some of the decisions that were released were not known to the tribunal prior to its reporting. So we say that those decisions have to be considered in determining the extent of the breach that the tribunal has already found.
Thank you. I'll just ask the members if they have any questions. Professor Williams? Any questions? Ms. Kapua has a question.
Kia ora, Ms. Charrington. I just wonder, in terms of that last matter you raised about the matters that you consider should be extended in relation to decisions prior to Ngā Mātāpono, can you just specify, in looking at that chronology, I was just a little unclear as to which particular decisions you were referring to that were pre ngā matapono.
Thank you, Ms. Kapua. I think what I'm referring to there is the discussions that were happening between the Crown prior to ngā matapono. And for example, the email that came from the Minister around asking for a shorter time frame for the bill, which happened on the 22nd of July. I say that those discussions are relevant to the exacerbation of that breach, and that wasn't considered when prior to ngā matapono, but definitely the discussions and the shortening of that time period has a real impact on the prejudice that we say the claimants suffer as a result of this bill, if enacted, or even without it being enacted. So I think it's more the information that surrounds those decisions that need to be considered.
Thank you for that. I just wondered too, in your submissions in 516 and 517, you refer to the objective being the Minister's objective to introduce the bill as soon as practicable. And then in the next paragraph, you say it doesn't align with the Crown's objective. And we've heard a little bit of evidence about what the particular objectives might be. But can you just clarify the objective to introduce the bill as soon as practicable? Is that the Minister's objective, or are you saying that's the Crown's objective?
Well, I would say it's the Crown's objective, but certainly it's being driven by the Minister in this instance. And I think that comes through quite clearly in the Cabinet materials in terms of the advice that's been given by Crown officials, the advice that's set out in the findings that are set out in ngā matapono, and the Minister's comments even in response to that in the Cabinet paper, which I'm sure we'll traverse later. But that he's certainly, it's a Crown decision, but he's certainly driving and committed to that pathway.
Thank you, Ms. Cherrington.
Thank you, Ms. Cherrington. I have no further questions, so we can begin hearing from Ms. Coates.
Perfect. I'll pass that back to you then, as I don't think she has any opening submissions or opening remarks to make. We're reminded of the time frame for today, so we had expected to just jump straight in there.
Ms. Coates, welcome. It's great that you could make yourself available again at such short notice and produce such a helpful brief. Would you like to just spend a minute or two summarising the content of that for those who are watching?
Ai, o te tuatahi tēnā koe e te kaiwhakawa, o tira kia koutou katoa ngā mema o te rōpū whakamana i te tiriti o Waitangi ki aku hoa mahi hoki o tira ki te Corona. Yes, ma'am. So I hadn't prepared introductory remarks, but I'm happy to make a few comments about the brief and what I was asked to do by the tribunal. So I guess, as you're aware, ma'am, we're asked specifically to provide an updating brief based on Crown actions since the last tribunal report was produced. In terms of those Crown actions, I don't have sort of access to all of the internal correspondence of the Crown, but in terms of the key steps that have taken and that I've commented on, I comment specifically on the Cabinet paper and the decisions that were made by Cabinet, which was effectively to continue to progress with the bill, despite the tribunal recommendations that it be abandoned. And also they made a number of key decisions about the shape of that bill and what it would include. In particular, a re-articulated set of treaty principles, which I've commented on. They've also made comment on the effect of the bill, i.e. the scope and how wide an impact it would have. They seek to include a comment around the bill not altering or amending the text of the treaty, and so I make critical comment on that. And then they also, and I haven't commented on this in my brief, but they also have a clause around this ultimately going to a referendum. So I guess just in terms of my overarching comments, in terms of those key Crown actions, I comment on the impact on the treaty text itself, i.e. what they attempt to do is incorporate, or there's a direction that a clause is incorporated that the bill will not alter, amend the text of the treaty or treaty settlements itself. My overarching comment on that front is that attempted assurance doesn't provide any form of comfort. Whilst the bill will not literally rewrite the text of the treaty, that will be the ultimate legal effect that it has. So despite that, it purports to be really an attempt to assure or have some form of assurance, but it's hollow in that that ultimately what is being done will have the effect of rewriting it for legal purposes. In terms of the re-articulated principles, I'm happy to delve into that in questioning if the tribunal would like. But my overarching comment is that the intention is still to ultimately uphold the ACT Party policy principles. They've just slightly re-articulated that. So I guess whilst there has been an attempt at redrafting, ultimately they haven't fundamentally shifted the intention of what that policy was trying to achieve. And I make a comment in my brief of evidence around how there's almost a disingenuous way of approaching it, in that it purports to now mention Māori in their new Article 2 that tries to sound better. But if you delve into the text, actually, to Māori concerns at all. So there's a sort of fabrication of it and a myth of it being better because now we're mentioning Māori rights, but the effect is still to ultimately extinguish tino rangatiratanga and define those rights in a completely Crown self-centred way, i.e. they're subject to only where the Crown recognises those rights. My ultimate conclusion, I guess, in terms of the rewrite is that there is no fundamental shift in articulation from, well, there's a shift in articulation, but not a shift in effect in terms of what the tribunal has already commented on. I go on to also talk about the flawed rationale that was addressed in my first brief of evidence, but I go on to make a number of comments about that. And I really just conclude by pointing out that the Crown is really, in this instance, I guess, continuing to doggedly introduce this bill against the advice of and recommendations of the tribunal, against the advice of their own internal advisors. And that really, instead of taking steps to undo the damage to the Māori-Crown relationship and attempt to restore Māori confidence in the honour of the Crown, they continue to really gouge a path that only deepens what is already a fractured relationship. So sorry, ma'am, that was a bit all over the place.
I think you did very well. Thank you.
Summarises the key articulation.
Thank you very much. It gives people an idea of what you've covered before we start questioning you. So, Professor Williams?
Tēnā koe, Ms. Coates. Nā mi o te wā ki a koe. So I've just got a couple of questions for you. Thank you for your second brief of evidence. As you are aware, we relied on some of your remarks quite a lot in our interim report. So if I can take you to paragraph 8 of your brief, you are quoting the Cabinet paper that talks about that the revised principles should assist with interpretation of any enactment where treaty principles would normally be considered relevant. And then in paragraph 10, you go on and say that these new principles will, if enacted, apply in a vast range of statutes. And I think your first brief of evidence referred to the Huakina case. And in the Huakina case, there was absolutely no reference to Māori whatsoever. But the remarks made by the judge was that the social fabric of the nation required the treaty to be taken into account. Can you elaborate a little bit more on what you think the word normally means in paragraph 8, quotation from the Cabinet? Because it looks, well, I'll put it to you that it could be every single statute in the whole country potentially relates to Māori if the interpretation of the courts in Huakina and Barton Prescott and others.
Yes, I think that's correct. As you would have seen in the Cabinet paper, there were a number of options that were considered in terms of the legal effect that that the treaty principles would have. One of those options, for example, would have been to limiting it to when the Treaty of Waitangi was expressly mentioned in legislation, but that was not the option that was selected. So the option that was selected in my submission was the broadest option, which is effectively that it will apply when normally relevant. As you've mentioned, I've traversed the jurisprudence of that in my first brief of evidence, and I think you're right in that the way that courts have interpreted the relevance of Te Tiriti o Waitangi is that it will have an interpretive dimension that can be overlaid effectively where it is relevant. So that kind of, as I've mentioned previously, it brings Te Tiriti o Waitangi into what we call the principle of legality, i.e. the presumption will be that whenever we're reading legislation, we will presume that the Crown is attempting to act consistently with Te Tiriti o Waitangi. Therefore, the lens that we cast over all legislation where Māori interests are relevant, the interpretive lens that is currently available is that we can draw on that to help the interpretive task. What this is saying is that this will effectively completely replace the way that we view Te Tiriti o Waitangi, i.e. These new principles will be what guides that interpretive task whenever Te Tiriti o Waitangi is invoked. So I guess the point really to be made there is that it's as articulated in this Cabinet decision, it will have extremely wide, broad-reaching implications, not only where Te Tiriti o Waitangi is mentioned in legislation, but wherever Māori interests are invoked and where Te Tiriti o Waitangi could have been used to help interpret the law.
Thank you. That's a very clear answer. Can I take you to paragraph 33 of your brief? You were talking about the re-articulated, I think was your word, Principle 2, and you say that that is in some ways even more insidious than the previous one based on the ACT Party policy, which had some cherry-picked te reo Māori words from the treaty and so on. So you say that Principle 2 is even more insidious. You will have seen, I presume, the evidence tabled by the Crown from Mr. Chana, who talks about that new wording as attempting to mitigate to a limited extent some of the concerns raised. So you think it's even more insidious. Mr. Chana thinks that it was an attempt to mitigate. Any comment on that, please?
Sure. I mean, what it does is, I mean, the previous iteration didn't have any specific mention of Māori rights and interests. So it had tino rangatiratanga of everybody. So in that way, it really eliminated the tino rangatiratanga or the unique kind of collective tino rangatiratanga rights of Māori and really attempted to blanket that out. What this does is a reframing of it. So it, on its face of it, says we're going to recognise Māori rights as of 1840, but what is important is the qualification that is then made, i.e. we're only going to do that where the Crown recognises those rights in legislation and in treaty settlements or in other agreements. The ultimate effect of that is to completely extinguish Māori collective rights of tino rangatiratanga. They have no independent meaning, but for when the Crown has said we recognise it. And the extent to which they recognise it across law is limited, and I go on to talk about the bounds and the limitations of treaty settlements. So I guess what I mean by this as being a more insidious thing is it's sort of purporting to say, hey, look, we're doing something about it, whilst not actually doing something about the recognition and the concerns of Māori in terms of actual recognition of Māori rights and interests under Te Tiriti o Waitangi.
Thank you. That's my questions.
Ka te tēnā koe e turi nā awa. I've got a couple of questions. First, in Paras 11 to 14, following on from my colleague, you discussed the impact of the bill on the treaty text, and you explained that while the Cabinet Minute affirms that the bill will not amend the text of the treaty, but in an almost sinister way it actually will. So are you suggesting the purpose of the bill, what's really going on here, is an attempt to diminish the treaty's significance and influence over government's actions?
Yes, although I think in this context, what it's attempting to do is to minimise the relevance of Te Tiriti o Waitangi to any time it's legally relevant in the law. And so it's not just in relation to government's actions, it's relation to all actions where Te Tiriti o might be relevant in the law. So it's a complete legal diminishing of Te Tiriti o Waitangi. And I guess in terms of that affirmation that it doesn't alter like the text of Te Tiriti o Waitangi itself, that is a completely, in my opinion, hollow line that will be added to the bill, noting we don't, of course, know the exact parameters of how it will be phrased. Because, of course, it won't go in and like literally take the Te Tiriti o Waitangi in Wellington and kind of scrub it out and be like, we're changing it. But in effect, what they're wanting to do is change it in terms of every time it is legally relevant, i.e. it will have no independent effect outside of how the Crown defines it to be. And so I guess that's where I really say that that is a hollow sort of recognition that, again, seeks to sound better, I think, but doesn't actually have the effect of being better.
Thank you. And in paragraph 14, with what you've said, wouldn't supporters of the bill, potential supporters of the bill, be able to argue that the existing principles developed over the past 3 decades are also a rewrite of the treaty?
Yes, I think that is one of the criticisms that has been made by a number of people over a long period of time, including the likes of Anemi Kaire, Moana Jackson, etc. So I'm not coming at this saying that the principles as articulated over time have always reflected the actual intent of Te Tiriti o Waitangi. So the whole concept in and of itself does have a number of fundamental flaws. But the qualification, I think, to that is that at least in the context in which those principles have been developed, in particular the Treaty of Waitangi, Māori have had a say in that, and you've had an independent arbiter coming out and articulating those principles. And they have developed over time. Tino Rangatiratanga is now more central in the interpretation than it was before. So I think we are moving slowly to a closer conception of Te Tiriti o Waitangi in the articulation of its principles. So this is not to say that the principles as developed are perfect or that they perfectly capture the text of Te Tiriti o Waitangi itself, but at least there was an independent person where both Crown and Māori were involved in the articulation of that. And so as developed, I mean, they more accurately reflect the balancing of the two texts than what this does, which is a complete, fabrication that is totally misaligned with Te Tiriti o Waitangi and the Treaty of Waitangi itself.
Kia ora. And my last question is a more general one. Do you believe we need a national conversation about the constitutional arrangements in this country?
He pātai pai tina, and I addressed this broadly in my brief of evidence as well, where one of the purported policy justifications is that this will generate debate around our constitutional arrangements. My critique about that is that the manner in which that debate is playing itself out and is not something that is healthy to a productive debate and constitutional conversation, because it is being led by a political imperative. It is being led by a small party appealing to a particular type of people, and it is being led in a manner which is grounded in false myth and narrative around what Te Tiriti o Waitangi actually says. So if we were talking about a healthy, constitutional, balanced educational debate in respect of our country, then yes, I think that is a good thing to have, but that is not what we're having at the moment.
Kia ora and thank you again.
Tēnā koe.
No kapua. Dr. Grant Phillipson.
Thank you, Judge. Tēnā koutou katoa. And tēnā koe, Ms. Coates. Thank you very much for your second brief of evidence. The first one was also extremely helpful. I just have 3 or 4 questions. The first one is that you've expressed in your brief that the principles, the redrafted principles, are not what they should be, but you haven't said anything specific about what you see as the flaws in Principle 3. And I wondered if you could elaborate on that, or whether you think that's a fair articulation of what Article 3 of the Treaty Te Tiriti says and intends.
Tēnā koe mō tērā pata. The reason that I didn't comment on that specifically is that I think I dealt with it in my first brief of evidence, and the tribunal sort of has already made comment on that. And so I guess there wasn't a huge fundamental shift in my mind from the flawed manner in which it was approached the first time, i.e. It is in capturing that equality before the law and that anchoring of human rights. But the issue, I think, is that of course, doesn't reflect what Te Tiriti o Waitangi was actually doing. And I think the tribunal has already commented on that. So that's the reason I didn't re-articulate a critique of that particular principle.
Okay, thank you. One of the key issues that I think we're being confronted with here is that the answer, almost the Trump answer, not Donald Trump, Trump and cards, I'll make that clear, is that the coalition agreement says we have to do it, so we have to do it. And I wondered what the answer to that is in treaty terms, in your view.
Well, in my simplistic view, I mean, yes, that preempted coming into power, but you are now the Crown, i.e. you collectively are the Crown, and collectively as the Crown you have Te Tiriti o Waitangi obligations. And so appreciating that everyone comes in with different policy imperatives, but as soon as you step into that role, you have those obligations that sit on you as an executive, and therefore you should and can be judged against consistency with Te Tiriti o Waitangi on that front.
Okay, so there's not some way of making political parties consider their future treaty obligations when they're preparing coalition agreements?
I mean, they certainly should. Because that's all prepared in light of the hope that you will become a part of the executive, and therefore you have those Te Tiriti o Waitangi obligations. But currently there is no, I guess, legal requirement to do so. But in light of the general obligations that are on the Crown in respect of Te Tiriti o Waitangi, all parties should certainly have in mind that in the hope that they will come into power one day and be in charge of exercising those. I.e., in this particular instance, the National Party, as the major political party, should have had their treaty obligations in mind when they engaged in coalition negotiations to ultimately seek to become the majority in Parliament.
Right. Thank you. That's helpful. In the officials' briefing, they proposed an alternative principle 2, which they considered more effectively articulated the intent and spirit and wording of Article 2. I wanted your expert opinion on whether that you would have accepted that that was a fair and accurate articulation, or whether you thought there were problems with that as well.
Aroha, I haven't had a chance to read through everything in advance of this, just because of other competing commitments. But if you're able to tell me it, I could give you an immediate reaction.
I can't actually remember all of the bits, but it was quite a lot more extensive and more faithful to what they were originally proposing back in the earlier memorandum. Could I put that question in writing so Ms. Coates has a chance to look at it? I know she'd have to give a very fast answer, but...
Yes, that's fine.
Okay, thank you.
And I'm happy to do so.
Thank you, Ms. Coates. Do you think we're returning to the days of assimilation?
Have we ever really left those days?
Okay.
I don't know. One of the things that I've been interested in terms of how the race relations debate has been playing out more broadly in the last year or so is this real rejection of any race-based policies, i.e. that's sort of a central tenet of the ACT Party, and they've brought that into government ultimately. And I think that question is particularly pertinent because whilst race is a broad category that sometimes is a blunt tool in terms of its equivalency with need, if we as a society start to move to a state where race and culture is completely irrelevant, then we will have moved to a state where assimilation is complete. I.e., if it is no longer relevant that you are Māori, that you have whakapapa Māori, that you have a long-standing relationship with the whenua and all of the rights that flow from that, if we move there, then I think you're right that the assimilation task will have ultimately been completely successful.
Yes, because I was just thinking that every government, or not every government, but many governments go through a phase like this. Helen Clark's government went through this phase, and yet the treaty survived and continued to be relevant. Do you think that's the case here?
I think Te Tiriti will always continue to be relevant as long as Māori exist and continue to assert rights and interests, which I don't ever see stopping. So Te Tiriti o Waitangi itself cannot be erased, but what they're attempting to do here is really minimise how it's relevant in terms of the laws of our country, which is deeply concerning given its constitutional significance in our nation.
Thank you. And just my last question is about the Principle 2. I was thinking about that. There wouldn't, for example, have been a commercial fishing settlement if Māori rights and interests were confined to exactly as they had been in 1840. Do you agree with that?
I mean, I agree that Māori rights and interests, like all societies, they move and shift, and that as part of Indigenous discourse that you have a right to development, i.e. you're not stuck wearing grass skirts for the rest of your life, right? And yes. So I think that's correct in terms of the way that fishing has developed. But Māori have always had aspects of trade and commerciality, so that's just a natural kind of development that different tools are then used to express that right. And so freezing it at 1840, as I think I sort of point out, doesn't allow for that natural development of rights and interests to occur in the way that they normally would.
Yes, okay. Thank you very much, Ms. Coates.
Tēnā koe.
Kia ora. I just wondered if you could have a look at your paragraph 15 and the new clause for Article 2, principles, or Principle 2. The way it reads, it seems to read retrospectively rather than prospectively. Would you agree?
In terms of it applying to when Māori sign the treaty, as opposed to it having an ongoing legal effect now?
It's the second part of it. Those rights differ from the rights everyone has a reasonable expectation to enjoy, only where
yes.
They are specified in legislation, treaty settlements, or other agreement with the Crown.
Yes, I think so. Although possibly if there are future agreements with the Crown, it might be captured depending on how it's articulated. I don't think it's entirely clear that it would sort of freeze treaty settlements as they exist now and not capture those ones that are coming, for example. So I'm not 100% sure that it would only apply retrospectively. It might depend on whether the language lands, but I'm not sure that as articulated it would necessarily have that effect.
All right, thank you. Derek Fox is online too. He may have a question for you.
No, okay to play. Thanks, Judge.
Okay.
I'm fine.
All right. Well, thank you again, Ms. Coates, for your evidence. We are going to find it extremely helpful in the next iteration of our report.
Tēnā koutou.
Kia ora, thank you again, Ms. Coates. Nei rā te mihi ki a koe I tēnei ata. Kia ora.
Can I just ask Mr. Allen, were there any questions you wanted to ask as a result of the tribunal questions?
No, thank you for asking, Mum. We have no follow-up.
Thank you. All right. Well, you're free to go now, Ms. Coates.
Thank you, ma'am.
So we're now running a bit ahead.
Tēnā koe, Your Honour. Associate Professor Willis is here and waiting, but does Your Honour want Council to provide some brief opening submissions?
Very good. Yes, that would be helpful.
All right. Now, we filed some opening submissions on the 26th of September, and the document number is 2.6.21. And I'll just go straight to paragraph 3, and that sets out in bullet point the claimant's case. And the first breach, and the fundamental one really, is this attempt by the Crown to unilaterally codify the principles in a way that's textually and historically inaccurate. So the main issue for the claimants is that it's just highly inappropriate for the Crown to do this in the way that it is doing. That document was between the British Crown originally and between Māori. So it was between an international law, two sovereign states, and it's really just inappropriate to be putting very important constitutional questions like how should that document be interpreted out to the public via referendum, and to have it even be the subject of a coalition agreement. If the treaty is to be interpreted in a way that will have a legal impact on domestic law, then it should involve the Crown as one party and Māori as the other party, not be put out to 80% roughly of one party having a say and 84% of one party having a say and 16% of the other, because that makes it completely unbalanced. So the point really, it's a legal agreement, two parties, both parties should have an equal say in terms of how that document is interpreted, not one party have 88% of the say and the other party have 16% of the say. If there is a disagreement, we have certain concepts in democratic nations, like the rule of law, and like that as a matter of justice, where there is a disagreement between parties, that they go to an independent arbiter. This is not the case here. The Crown doesn't want the courts and the tribunals as semi-independent to interpret that document. They don't want that at all. They instead want to go back to this idea of one party gets 88% of the 84% of the say, and the other party gets 16%. And that is completely unjust. And it's against everything we've ever known or been taught about how justice should occur in this country and in any civilized nation. So that's really fundamental. We had some tikanga and te reo evidence filed by Mr. Hone Sadler, and that's been taken as read. And his document number is A4B. And he says at the end that actually the rangatira who signed Te Tiriti would never have imagined that somehow where there was a dispute, that they would be given so little say in how that dispute was to be resolved. And at tikanga, that is not how disputes between parties are resolved. So that's the tikanga evidence there. There's also evidence provided by Associate Professor Willis, who will be on shortly. But in terms of the actual interpretations that are being put forward on behalf of the 84%, Article 1, that is not actually what the treaty says. So they're proposing a principle which gives essentially the 84% control of everything. The independent arbiters who have been the tribunal and the courts have already concluded that that's not what the principle says or what the article says. The same thing with Article 2, the way that that's articulated in the Associate Ministers and a version or second version of the treaty, again, is completely at odds with what that article says. And the same thing with Article 3. And so really the claimants oppose this codification, but their central point is that it's just wrong for the Crown to be engaged in this exercise. They should not be involved. There should be no referendum. And this sort of material, in terms of the interpretation of the treaty, should not be the subject of political whims, let's say. And those are our submissions, Your Honour.
I'll start with Dr. Phillipson. Do you have any questions?
No, thank you, Judge.
Derek Fox?
No, thank you, Judge.
Dr. Suter?
Oh, no, sorry.
Ms. Kapua? And Kevin Prime? And we have no questions, so we're ready to hear from Dr. Willis. Professor Willis.
Thank you, Ma'am. Dr. Willis or Associate Professor Willis is online, and his brief of evidence is A33. And he'll give a short presentation or summary of his evidence before answering questions. Thank you.
Professor Willis, welcome. Thank you for stepping into the breach for Professor Giddies with very limited notice. We do appreciate it.
No trouble, Anna. Ngā mihi nui to the tribunal. Thank you for this opportunity. To sort of contextualise my evidence, I came at this very much from a Western or a Pākehā constitutionalist perspective to try and assess the proposed bill through that lens. And two real drivers for that, I guess. One is the Cabinet policy document itself, I think has, it tries to articulate a constitutional policy problem, suggesting that the way Te Tiriti is currently being interpreted by the courts or used by the public service, or the way that the tribunal has interpreted it is somehow inconsistent with how we would understand liberal democracy. And I try and articulate in the evidence that that's not really the case at all. The development of Te Tiriti and its principles, the way it's been recognised in law, the way it's been recognised in the public consciousness, the way the public service has tried to better accommodate and synthesise the promises inherent in Te Tiriti, is very much a natural and ordinary and expected and orthodox approach to constitutionalism. The other aspect, I think this is more implicit in the Cabinet paper, is kind of an attitude, well, we can kind of just do this anyway because parliamentary sovereignty means we can do what we like. And I think it's really important to, I'm probably going to use this word too much, but contextualize what parliamentary sovereignty actually means. There's a very rudimentary, but I think superficial understanding that parliamentary sovereignty lets Parliament, through sort of majoritarian representation, enact any law that it likes. I think it's important to understand that that is the usual way that we would accept Parliament's legislative authority, but it's very much premised on a constitutional orthodox use of that power. Part of the reason we accept parliamentary sovereignty in that way is because it's not challenging constitutional fundamentals on a regular basis. And indeed, I don't want to pretend that that has never happened. When we do see constitutional fundamentals being challenged by legislation, that creates real problems within our constitutional system. It's at the very least undesirable, in that there's a tension sitting within the constitutional system between the law on the books and what we all know to be the fundamental constitutional promises or principles we're trying to realise. And that has to be resolved one way or another. Usually in the course of our constitutional history, thankfully, Parliament has exercised its legislative authority in a way that is increasingly more consistent with constitutional fundamentals. And what the Cabinet paper and the proposed bill want to do is enact something that's directly inconsistent with constitutional fundamentals. Now, I am not the sort of expert that Ms. Coates is on the interpretation of treaty principles and what they mean and how they should be realised, but I don't think you need to be to realise that these are inconsistent. The principles as articulated in the Cabinet paper are fundamentally inconsistent with the promises in Te Tiriti, the kind of power sharing arrangements and the recognition of Indigenous rights that are fundamental to any sort of orthodox, ordinary understanding of what Te Tiriti means. So by trying to set legislation up in opposition to the substance of Te Tiriti, it creates constitutional problems. I go on to speculate, and it can only really be speculation at this stage, as to what that might mean if this proposed bill was enacted and sort of entrenched is probably too strong a word, but formalized this tension between a legislative definition that is completely out of step with constitutional substance. One option, of course, is that the tension just becomes unbearable too quickly and Parliament reverses it very quickly. That might happen on a change of government. It might happen more quickly than that. The other option is that it persists in some way. It can, as I think has already been said by Ms. Coates and others, it cannot change the actual substance of the treaty. So there's just this constitutionally fraught situation that we're always grappling with. How far do we go? Have we stymied the natural, ordinary development of recognising treaty principles going forward because the law is set up in opposition to that? The answer is probably until something really pushes things to the point where there's got to be some release of that tension. And ultimately the question, and this is what I was asked to address in my evidence, is does this get us to a point where there are clear limits on parliamentary sovereignty? Can we say that Parliament has actually acted unconstitutionally when it's enacted this legislation? And again, while this is speculative, that's not an outrageous argument given the constitutional context we're dealing with here. I would say that there are already limits on parliamentary sovereignty. They're just prudential limits or political limits, where Parliament usually doesn't want to enact this sort of legislation for very good constitutional reasons. Parliament does not go out and try and create this sort of constitutional tension. And that's informal and non-legal, but that is very much a practical limit on how Parliament usually legislates. The question becomes, if Parliament is ignoring those practical political limits, can the courts then step in and put some sort of legal limitation around it as well? That is a very difficult question to answer, a very fraught question to answer. It invites a fundamental reassessment of our constitutional fundamentals and how they play out in particular contexts. I don't think it's a question we could answer in the abstract. I think it would take a particular challenge to the courts and the merits of that particular challenge to see what would happen. But I do note that the idea of legal limits on parliamentary sovereignty is itself not a wholly radical idea. There's been increasing judicial and academic recognition of what we call the manner-informed theory of parliamentary sovereignty, which suggests that there is some role for legal limits. The last time this was tested in the Supreme Court, in an argument, the Crown accepted that that was the appropriate theory to be applied. So there does seem to be widespread agreement that legal limits are something that is possible. If this proposed bill was to be enacted, and largely the form it is in now, it's going to bring those tensions to a head. And so we're going to have real questions about whether or not the courts can step in and say, no, this is actually beyond the constitutional pale. This is beyond what Parliament can do, certainly constitutionally, but now perhaps also legally. I think I'll leave it there because I'm sure there are plenty of questions, but that's sort of the Pākehā constitutionalist perspective on where this is all going.
Yes, thank you. You raise numerous issues that we're very interested in exploring. So, Professor Williams?
Good morning, Dr. Willis. I'm pleased to see you again in the far south. You and Dr. Phillipson both seem to have quite a lot of hair on the top of your head, so that keeps you warm in the south there. And I hope you're doing well after your move from Auckland to Otago. So I have a few questions. I would quite like to have a whole long seminar with you, but we will restrict it to a few questions. At paragraph 17, you talk about the recognition of the treaty and its principles has been an evolving but still relatively conservative understanding of the requirements of constitutional democracy. And so I'd just like you to explain a little bit what you mean by using the word conservative, because there are campaigning politicians who have expressed absolute outrage that judges and the Waitangi Tribunal have come up with all of these terrible ideas over the last 50 years. But you call this conservative, so what does that mean?
I guess with the use of that word, I was really trying to capture a process of incrementalism. I don't think it's the case, although there is some political rhetoric to the contrary, that these gradual steps towards greater legal recognition of te tiriti are radical or pushing the boundaries. The courts are by nature an incredibly conservative institution. They tend to keep in step with public opinion, and by that I kind of mean majority public opinion. And yes, they may sort of push the boundary at the margins, but they're usually making decisions that accord with popular understandings, or at least they're just moving popular understandings in a very sort of incremental way. So it's not the case that the courts sort of, in any of this jurisprudence, come out and put a new stake in the ground that is sort of a million miles away from where the development has led to that point. While particular judgments seem to get an undue amount of attention, and then people sort of take this one judgment in isolation and cast it as a sort of radical or a bit left field, it is very much a building up of an evolution of jurisprudence that is very natural and very ordinary and very orthodox. I also kind of make the point that it's taken 180 odd years to get to this point. And I don't think that is a radical time frame at all. When I sort of say conservative, this has been a very slow process. And I think there's certainly potential for greater recognition of te tiriti and its principles and its underlying promises. And we're not there yet. So I struggle to sort of describe this process as anything other than conservative, because I think that that's really what it is. It's, in some senses, it's almost the bare minimum, and we're still fighting for more and more and more. And that's the way it should be. Our constitutional system should be working out how we better accommodate these things all the time. And I think that has been a slow, gradual process and could have been faster.
Good, thank you for that. You earlier in 16D used the term soft form of justiciability, absent legislation, and you and I have both had discussions about soft form justiciability in the past, but for the purposes of this hearing, could you just expand a little bit on what you mean by soft form justiciability as opposed to presumably to hard form justiciability?
Yeah, I guess what I mean in that context is, if we start with sort of hard form justiciability sounds funny when you say it, but a clear legally defined justiciable standard is probably what we mean. So if the treaty principles are incorporated into legislation, we can very clearly see, well, there's an objective justiciable standard that the courts can apply. Where that's not so clear, I think this language of soft form justiciability makes a lot of sense, because it's sort of saying, well, the courts will look at this as a consideration. It may not be a sort of a legal directive, but it's something that influences the way that the law is applied. And so when te tiriti is not being recognised in legislation sort of expressly, where it's being read in through implication and things like that, for a long time it's been hard to treat that as more than just, well, there's a consideration here which is a te tiriti consideration, and we will factor that in, but it's not sort of the driving force of the legality. So it's a contrast between where te tiriti becomes part of the standard of legality that needs to be applied because it has express recognition, versus it's certainly relevant, but its relevance is limited in some way because it's not directly recognised in law.
Great, thank you. So my final question is, I need to unpack it a little bit, but it relates to your paragraph 20, which talks about standards of constitutional propriety, and I think you have a reference to the UK Miller case. And in paragraph 25, you talk about, when you're talking about this notion that Parliament has full lawmaking powers, you talk about the fact that government and Parliament will continue to act in a constitutionally responsible manner. Constitutionally responsible manner and standards of constitutional propriety. Now, as you're aware, we of course are not a court that can make decisions on these matters. We're a tribunal that does, though, apply principles such as the principle of good government or good governance. So if you can think of that as the target that I'm aiming my question at. Do you happen to have come across Eileen Kavanagh's Collaborative Constitution book published in 2023?
Yes, I can't say I've read it cover to cover, but I am familiar with it.
So this the notion of collaborative constitutionalism requires constraint by the different parties to the separation of powers notion. So is there anything in what she has written and what you have said in your brief that enables us as a tribunal to make some findings that require some form of restraint, constitutional propriety, constitutional responsible? Can you unpack that a bit as to something that can help us to make some findings that might be useful?
One of the distinctive things about New Zealand constitutionalism, and we can bring the UK into this as well because it's the same tradition from a Pākehā Western perspective, is a bit of a strange separation between what is lawful and what is constitutional. And one of the consequences of that is that Parliament can pass legislation and change the law, but can be acting unconstitutionally when it does so, can be changing the law in a way that is inconsistent with constitutional principles. So when I use that language about acting in a constitutionally responsible way, or being aware of standards of constitutional propriety. That is a desire to see Parliament exercise its legislative or legal power in a way that matches up with its constitutional authority. What Aileen Kavanagh has done in her work is try and broaden out the interface between the different branches of government and really say everyone has a role here, and to work out what's constitutionally appropriate, we need to have a voice from the courts, we need to have a voice from Parliament. She's particularly interested in Parliament and the courts because she writes that theory up in the context of the Human Rights Act 1998 in the UK, where there is this tension between Parliament and the courts. And she says both players need a voice. It doesn't make sense to say, for example, Parliament makes the law and the courts interpret it. Parliament is certainly making the law, but so are the courts when they interpret it. It is a joint exercise. And so a degree of mutual respect and mutual restraint is very, very important. Now, what does all that mean for the tribunal and the standards that it can apply when it sort of assesses these matters? I don't think it's beyond the tribunal's jurisdiction to say, for example, this action is unconstitutional because it's inconsistent with Te Tiriti and its principles. That is part of the tribunal's role, is to articulate those things and say, this matter's been brought before us, we need to understand how Te Tiriti relates to this. Actually, what Parliament or the Crown is proposing is going to be inconsistent with that. Well, that's inconsistent from a Te Tiriti standpoint. It's also inconsistent from a good government standpoint because it breaches these standards of constitutional propriety. I appreciate that the tribunal might feel like it was on stronger ground if it focused solely on this is the treaty inconsistency. But Te Tiriti has a promise of good government and responsible government within it. And when that crosses over into this balance between rangatiratanga and kāwanatanga, which is essentially what any sort of sovereignty question amounts to, that's certainly something that I think the tribunal can comment on in a constitutional context as well as a Te Tiriti context. I hope that's answered your question, David. There are many strands to it.
No, that's very good. Thank you very much, and thank you for elaborating further on the evidence that Andrew Geddes gave to us in the first hearing, and taking it a bit further in a way that's very useful. So thank you.
Cool. Thank you.
Yes, and at the risk of jumping in, because the only questions that I wanted to explore were around the concept of parliamentary sovereignty, I'm going to ask my questions now. So I'm no doubt that Professor Williams will school me about this in the break, but because I haven't run it past him. But would you call the doctrine of parliamentary sovereignty a English law that was imported at 1840?
A short answer, yes. So it's very much derived from the English historical context. So when you think about where parliamentary sovereignty comes from, it was this historical context, battle, if you like, between the Crown on the one hand, the monarch, and Parliament, saying we are the representatives of the people, at that stage, a select group of the people, but we're a representative institution, and we should have some authority over this. The king or the monarch can't just sort of rule by decree. There has to be consultation with Parliament, there has to be legislation. And the courts historically in England have acquiesced to this, to say, well, we will recognise parliamentary enacted legislation as the primary source of law. That is very much an English doctrine developed in a context that is completely isolated from the idea of, I was going to say colonisation, but that puts kind of the wrong lens on it. The need to have different peoples from different cultures living together and finding a way to express and realise those different cultures. It's completely alien from a context where some sort of power sharing at the constitutional or the political level is a realistic prospect, and indeed is probably needed.
Right. Then my next question is, the English Laws Act of 1855, I think it is, makes all law from England applicable in New Zealand to the extent necessary to meet the circumstances of the colony, doesn't it?
Yes.
So isn't there a potential argument to make that to the extent that the circumstances of the colony required, first of all, the treaty to be signed in 1840, then the guarantees provided by way of the treaty should dictate what the metes and bounds of parliamentary sovereignty should be?
Just for the record, 1858.
Oh, 1858, sorry.
It's nice to have a legal historian like that.
It's great.
On call, isn't it? Again, short answer, yes. I think there is an argument there. I would, from my own point of view, be less focused on, is there a technical legal argument where we can point to a statute and say there's a way we can trace this back? My preference would be to say, what does and what should parliamentary sovereignty or parliamentary authority, to use a slightly less loaded term, mean for us in a modern context? And Professor Geddes made this point, and I reiterated in my evidence. Very much, it's an expression of a mix of constitutional principles.
Well,
and
all I really wanted to do was to ask you whether or not it's possible to run that argument, and there clearly is.
I think that is a feasible argument.
And I accept the point that your evidence is addressing more what contemporary parliamentary sovereignty might look like in current circumstances, but it's an interesting point. Kevin Prime? Dr. Suter?
Morena, and yes, thanks for stepping up for Professor Geddes. I've only got one question regarding paragraph 19, just a point of clarification. So in paragraph 19 you say, as to the assertion that that application of the principles of the treaty is vague or uncertain, this seems likely to be premised on a further misunderstanding of the role of the courts in our constitutional democracy. So my question was, is misunderstanding the right word there? Because if you think about it, the Parliament, the executive has access to all these officials and their expertise. It has no end of legal support. So how is it that they could arrive, that this could be a misunderstanding? Isn't it more that this is a deliberate attempt to mislead by using those words vague and uncertain?
I couldn't comment on the intention underlying the use of the words vague and uncertain. I did choose the word misunderstanding to give the Crown here, or the drafters of the bill, the cabinet paper about the proposed bill, the full benefit of the doubt. I think, to answer your point more directly, I think it is a little disingenuous, at least, to say that this is vague or uncertain. I don't think there's a lot of evidence of unanticipated or surprising jurisprudence or results coming out of consideration of Te Tiriti. I think it's a mischaracterization to say that it's vague and uncertain.
Thank you.
Dr. Phillipson?
Thank you, Judge. Tēnā koe, Professor Willis. I just have a couple of questions. My first one is about, actually it's a request. Could you mention in footnote 8, chapter 7 of the book Principles of Constitutionality, and I was wondering if you could file a copy of that chapter, please, for our record.
Certainly.
Thank you. My second question is about Principle 3, which I also raised with Ms. Coates, and that is about whether you think, you've read the Principle 3 that's proposed, it's in your brief, whether you think the right to equality as it's set out there, and setting aside that it's stated as a right for all New Zealanders, whether you think that it is sufficient to capture what is in the English version of the treaty, the rights and privileges of British subjects, And as Mr. Sadler has included in his evidence, Professor Patu Hohepa's translation of that, which is broader in terms of duties and obligations and rights. Do you think a right to equality is sufficient to capture all the rights and privileges of what were then British subjects? Now New Zealand citizens.
Yeah, of course. So I'm sort of reluctant to profess any expertise on the correct interpretation of Article 3 of Te Tiriti, either the English version or the Reo Māori version. But as you put me on the spot, my reading of that would be that Article 3 in the English language version is that it's opening up for Māori a range of rights and privileges that weren't available to them before, being the rights and privileges of being British subjects and in modern context, New Zealand subjects. So Māori are gaining something. I think the language of equality flattens that. Like Māori, there's nothing in Article 3 that says Māori do not have their own rights, their own interests, their own privileges as Māori. They just have a whole extra set that they get because of Te Tiriti and that power sharing arrangement with the British Crown. So the language of equality in the language for the proposed bill flattens that out a little bit, and it denies the unique Māori side of that. So I don't think the two are equivalent.
Yes, I think you might have missed the point of my question.
Oh, I apologize.
Which is, in terms of, I'm just asking about, in terms of your expertise, is the right to equality, is that the only right in the rights and privileges of New Zealand citizens?
No, thank you for the clarification. I do think that the rights and privileges of British subjects, of New Zealand subjects in the modern context, certainly extend beyond just equality. There's a whole range of constitutional rights that inhere in the individual that we see as being natural or as a result of you being a citizen of this country. And that certainly extends beyond just a right to equality.
Okay. Thank you very much. That's all my questions. Oh, actually, I did have one more. You've talked about, there's a lot of justification in terms of the cabinet paper, in terms of democracy. I wondered if you could just expand a little on what you've said in your brief in terms of how the rights of Indigenous people are not anti-democratic, but that they are in fact encompassed within what needs to be protected and recognised in a democracy.
Certainly. I really struggle with this idea that recognition that certain groups have particular rights is inconsistent with any concept of democracy. It is a very, again, I'll use this word, a very flat understanding of democracy to say that everyone sort of has the same set of rights and interests. Women, for example, have particular interests that men don't have. They have particular needs that need to be recognised in law. Particular cultural communities have particular needs that need to be recognised. I don't see any of that as being inconsistent with liberal democracy as we would usually understand it. We would see people as having a collection of rights, of entitlements, of needs, of desires to self-actualize or be part of a community or be part of a political group that are nuanced and diverse and interesting. Part of the role of liberal democracy is not to flatten that out and say, well, we're all one people, we all have the same sets of right and interest here, and we're just going to accommodate sort of the bare minimum, majorities rule type fashion. It's actually to work out in a sophisticated and nuanced and a lot of the time negotiated way, how do we accommodate these different perspectives, these different needs, these different sets of rights? That's what a constitution is. And I think we've moved away from the idea of liberal constitutionalism as we are all the same, we're a monolithic state. I think written constitutions for a long time had that function of trying to say we are one people, we are one monolithic collective. I think the reality is we've moved beyond that. If I can a quote from an academic named James Tully, which I think is quite apposite here. A constitution should be seen as a form of activity and intercultural dialogue in which the culturally diverse sovereign citizens of contemporary societies negotiate agreements on their forms of association over time. Like, it's this working out of what does it mean to be Māori in the New Zealand Constitution? What does it mean to accommodate Māori in the New Zealand Constitution? That is really the task of modern liberal democracy. And to pretend otherwise is sort of to downplay or do a disservice to the potential of that term. Liberal democracy is about including this diversity and finding ways to accommodate it at the level of individual rights, at the level of some sort of power sharing arrangements. This is all a very natural part of how we understand democracy in a modern context.
Thank you for your expert evidence, and it's been very helpful. Thank you.
Thank you.
Derek Fox.
Kei te pai au, Judge.
Fine. Ms. Kapua.
Thank you, Judge. Thank you for your evidence, Professor Willis. Just to carry on from Dr. Phillipson's question, in your evidence at paragraph 12b, where you refer to the fact that the Cabinet paper says that the Declaration on the Rights of Indigenous Peoples has no binding legal effect in New Zealand, and you're unclear as to why that should be expressed in that way. What's your view of the effect of the Declaration in terms of Māori?
Oh, it's certainly relevant. As an accepted standard of international law, it at the very least reaches the level of what Professor Williams and I were discussing in terms of a sort of soft form justiciability. It very much has, again, just from sort of an orthodox Western constitutionalist perspective, it is part of the context in which we need to understand and interpret the law. So in that sense, it certainly has some legal significance. It would take me a while to sort of research broader implications. I would not be surprised at all if it had been implicitly or aspects of it had been implicitly or directly incorporated into legislation in some way, and so it was directly relevant in that sense. To sort of make a categorical claim that it has no legal effect, I think has to be incorrect, although I framed it in that way that it was unclear as to why it was being said that way, because I don't know what sort of advice the minister and his team have relied on when they've said that. There may be an interpretation where that is technically true, but I think taken in isolation, it's certainly not.
Thank you. And carrying on with the issue around the modern liberal democratic values and the inclusiveness of other interests, is there a particular, in your view, a particular emphasis that exists in relation to Indigenous rights?
Short answer, yes. I'm just trying to think through the best way to explain this. When I sit down with my students and say, what are the core features of liberal democracy as they apply? We usually hit four things. One, democracy, in our context, representative democracy. Two, the rule of law, incorporating things like an independent judiciary. Three, human rights. And those first three are relatively universal. We would expect every major democratic society to sort of adhere to those things to a greater or lesser extent. And the fourth one is the unique things that make your country, your nation, your constitution different. And in our case, it's always te tiriti. And that hits in two ways. One, it's three ways actually. It's about what we would call in constitutional theory constituent authority, the foundation of the nation. Where does the source come from? Two, there's Indigenous rights. By virtue of being an Indigenous person in New Zealand, you have, by virtue of being Māori, by whakapapa Māori, you have a set of rights that are different that need to be recognised by the state. And three, there is a claim to sharing political power at the highest level. Exactly what those mean in terms of the detail, again, is something that I think we are constantly working out. But those are integral parts to liberal democracy as we would understand them in a New Zealand context.
So would you agree with the suggestion that this bill and how it is currently articulated reduces Indigenous rights to ordinary rights that can be exercised by anyone?
I think that's certainly an intended feature of it, and I think that's part of what makes it constitutionally problematic.
Okay, thank you. Thank you, Professor Willis.
Well, we thank you so much, Professor Willis, for your time and for the expert evidence you've provided. I'm going to ask Mr. Allen if you've got any follow-up questions.
No, thank you, Mum. We have no follow-up questions.
All right, thank you very much. Well, thank you, Mr. Willis, Professor Willis, for your time again. And you may leave and take the rest of the day to do what you need to do. Ngā mihi kia
Thank you.
koe.
Ngā mihi kia koutou.
So I did see Dr. Harris. I don't want to start him, though, unless he's ready.
Ms. Sykes here. If I did the opening submissions now and took questions, it's proposed on our behalf that Ms. Tahita will lead. Dr. Harris, he does have a few brief opening comments, and I'm happy if I can try and do my opening submissions to have that time so we can actually have morning tea, and
Yes.
then perhaps Dr. Harris start after that.
Yes,
I'm just
that'll-
trying to be considerate to the tribunal.
Well, I think that would be really helpful.
Kia ora. Can I take everyone, please, to our joint opening submission, which is appellation Y3300 3.3.36. And I want to highlight a few salient points, but perhaps what hasn't been highlighted by my colleagues to date is that there is a sole issue before this reconvened inquiry, and namely it's to determine whether the Crown's decisions regarding its Treaty Principles Bill policy since the publication of the interim Ngā Mātāpono report are consistent with the principles of the Te Tiriti o Waitangi. And in that respect, we set out at paragraph 6 of our opening submission the unequivocal conclusion in the interim report, Ngā Mātāpono, that the Treaty Principles Bill policy is unfair, discriminatory and inconsistent with the principles of partnership and reciprocity, active protection, good government, equity and redress, and contrary to the Article 2 guarantee of Tino Rangatiratanga. Furthermore, it is also in breach of the Crown's duty to act honourably and with the utmost good faith. We say, after consideration of all the new material, that there is no disruption at all to those findings of the interim report, and in fact there is now greater prejudice, as we've heard in some of the evidence already today, that is available, we think, for positive findings to be made by this tribunal, saying that the bill is both unconstitutional and a breach of the principle of kāwanatanga in the strongest terms. One of the matters we highlight early in our submission, and on that paragraph 7 and 8, is that while we were in the stage 1 of this inquiry, Crown documents were being prepared that could have been made available to us at stage 1. And that has been a concern in some of the process outcomes and issues that we've had to confront in terms of analysing material in an urgent way and trying to come to terms with the rationale or the Grundnorm of why things are happening. We note that several of the documents were prepared during the Tribunal's urgent inquiry, but were not disclosed by the Crown. This is a departure for us in some of the normal procedure that we've had in the way things have been more open in disclosure in the past, particularly on important constitutional matters of this. What is positive, though, about the new material that's now been made available to us is that the officials' advice confirm that Associate Minister Seymour's deliberately continues to pursue a policy that is in breach of Te Tiriti and its principles of tino rangatiratanga, kawanatanga, mutual recognition and respect. So what is, I want to emphasise is that officials' advice themselves have been corroborative of the initial views of this tribunal in its interim report. One of the alarming things is the truncated nature in which the analysis has been progressively more and more truncated, and the timelines to achieve the ACT Party's political objectives of introducing the bill by November 2024 have narrowed. That timeline has clearly driven the policy process, irrespective of advice from officials and following the Tribunal's interim report, and that is concerning. The Tribunal plays a significant constitutional role, which we've already heard about, and that constitutional role is about ensuring that future action of the Crown does not breach the Treaty o Waitangi. It seems that both the process and substance of the matters before the Tribunal are being developed in a way that is ignoring the fundamental constitutional function of the Tribunal, but more fundamentally is working to develop processes that are more about rewriting of Te Tiriti and will impact the social cohesion of the state. We set out quite clearly, and I'm not proposing to go through them, some of the proposed changes to Article 2 of the bill, which are outlined, and we set out at paragraph 14, and I think this is really important, those aspects of the Article 2 proposal that the regulatory impact statement itself has highlighted the problems with. And that's how we start this inquiry. We've already had a question posited by the panel on the objective of a national conversation that was put to Ms. Coates in her evidence today. We set out at paragraph 15 that the ACT Party's alleged purpose of conducting a national conversation is repeatedly exposed as a sham. I don't think that was the express language of Ms. Coates this morning, but we believe that this is certainly the evidence has disclosed, and the continuing dialogue today confirms that description by us is true. The process and timetable that Associate Minister Seymour has insisted on has not allowed for such a conversation, and certainly there has been no proper dialogue with Māori. At 16, we say that instead Associate Minister Seymour has systematically foreclosed the possibility of a considered, informed and broad-based constitutional conversation through his determination to treat Māori as one of the numerous ethnic groups rather as one of two state parties to Te Tiriti, the lack of prior or any engagement with Māori, the inability to engage constitutional and Te Tiriti experts on the drafting, the narrow parameters of the ACT policy that preempted a range of options, the lack of time to develop further options within those parameters, the decision not to proceed with an exposure draft for discussion and feedback, the select committee process that will consider submissions on a predetermined bill, and advancing a referendum that would likely seek a yes or no response to this distorted version of Te Tiriti principle. I'd like to now move to paragraph 20 of our submission, and this is our concern around the social cohesion of the fabric of our communities and our society that is being impacted upon by the current Crown actions. There is no doubt, as the officials themselves have pointed out, that ACT's proposed bill will increase and not reduce uncertainty over the principles of the treaty, where they appear in legislation and where they do not but might be inferred. The officials suggest that there is currently a degree of certainty around the treaty principles on the basis that the court and tribunal principles are largely settled. I think that is an important concession from the official. However, what they refer to as settled does not reflect Te Tiriti o Waitangi itself. And I think the jurisprudence has come to a point in the general courts where they see an important distinction between the text of Te Tiriti o Waitangi itself and the principles that have evolved to give force to the commitments made in that text. A particular point that is highlighted in the evidence of the witnesses that have been recalled by the tribunal is that we highlighted paragraph 28 of our opening submission. And that's the failure of the Crown to meet its own regulatory standards. The Associate Minister has failed even to observe the Crown's requirement for decision-making on legislation to be based on evidence and informed by officials' advice, in violation of the Crown's own form of good government, let alone a tikanga-based approach to government and governance that is required under Te Tiriti. And while the two witnesses aren't being called Professor Margaret Mutu and Dr. Sadler, I believe their tikanga observations give force to those matters. It's also a matter that was commented upon by the panel that convened for the urgency around the takutai moana matters, the principle of kawanatanga that's been breached, and we draw comfort from the analysis in that report highlighting the similar concerns that we have. I don't propose to go through that section, but that's a vital part of the theory of our case, which we wish to articulate and seek findings from in this part of the tribunal's inquiry. I wish to go to the prejudice, and I'll leave the evidence to be introduced by my learned friend, Mr. Hira, from that paragraph 34. We set out quite clearly that the existing and future prejudice that will be caused by the introduction of this bill, as identified by the claimants in the initial hearing and by the tribunal in its interim Ngā Mā Tāpono report, remain and have been compounded by the contempt displayed by Associate Minister Seymour for Te Tiriti following the release of that report. These include the confirmation of a lengthy select committee process for political purposes that will further inflame the hostility to Māori generated by providing a platform for racism and the further deterioration of Crown Māori relations, especially as the composition of that committee and its process for hearing and analysing submission remains unknown. From the response of Associate Minister Seymour to date, the Select Committee process appears to be a political stunt by the ACT Party, and that has no other purpose, assuming the other coalition partners remain opposed to passage of the bill. The claimants also recognise the risk that the National and New Zealand First parties could reverse their positions and the bill in some form might be passed. The prejudice to Māori caused by that would be devastating. It would create a prejudice comparable to the era where the rights and obligations enshrined by Te Tiriti were nullified by the courts. There is also an additional risk of prejudice by the preparations for a referendum, despite the current position of the New Zealand First and National parties that they will not support the bill. These preparations would provide the infrastructure for citizens-initiated referendum that would make the Treaty Principles Bill a platform for the next election. Again, the harm to Māori and to Crown Māori relations would be profound. Finally, the damage done to tino rangatiratanga, and by extension the rights for Māori in public understanding, would create prejudice. It would undo much of the progress made towards achieving Te tiriti justice described by our witness as constitutional justice and have a chilling effect on many of the efforts to continue this work. The norms trampled on and ignored around engagement with Māori as part of honouring Te tiriti would be prejudicial, as it normalises the fact that major anti-Māori constitutional change can occur unilaterally. Those are our opening submissions.
Thank you. Dr. Grant Phillipson, do you have a question?
Thank you, Judge. No, I don't have any questions. Just to thank you, Ms. Sykes, for those very helpful submissions.
Right, Mr. Derek Fox.
No, kei te marama kia, mana pōrero.
Thank you. Dr. Suter. Ms. Kapua. Kevin Prime. Professor Williams.
Ngā mihi o te wā ki a koe e hoa, Annette. Just a technical question about paragraph 16 of your submissions. What we now know is that the government is not going to proceed with an exposure draft, and nor did it make any progress on engaging constitutional and treaty experts. But given that you were opposed to those processes in the first place, I presume you're not arguing that it's a prejudice that they have not done that.
No, what I'm saying is that there are things that they contemplated that they might do show that this has all been a shams, if I can explain it in that way, that they put up propositions to try and influence the public, certainly, that they would take steps to test the quality of their proposition. And of course, they haven't done that.
Kia ora, thank you.
I don't have any questions either. Just thank you for enunciating and articulating the submission so well. Ngā mihi.
Thank you. Kia ora.
So we will take the morning adjournment at this stage. It's good that we're slightly ahead of time, because it means that with the request for cross-examination by counsel of Mr. Chana, we're going to fit everything in, I think. So, Dr. Harris, thank you for being here. I'll just ask your forbearance and let us have a cup of tea, and then we'll be back to see you at 11:15. Yes, well, we're all here now. We'll start again. I'm sorry for the slight delay. We've just sent out to all parties a copy of a news article from Radio New Zealand, which gives an extremely conservative estimate, it suggests, of $4 million to progress the Treaty Principles Bill. It's an article that captured my attention, and it's a matter I thought that I would ask Mr. Chana to address when he gives his evidence, but if anybody else wants to address it, I'm just letting you know it's now on the record. Dr. Harris. Ms. Sykes, do you, or Ms. Tehira, you are going to lead?
Ai, tēnā koe te kaiwhakawā matua o tira tēnā rā tātou katoa. Kua maringa nui a hau I tēnei ata. Ki te tuku I te kupu whakataki me te kupu whakaarara ki tō tātou kaitaunaki mātanga I Dr. Harris. So Dr. Harris will be speaking to his second brief of evidence in this inquiry, which is A9D. And his brief continues on from the submissions made by Ms. Sykes earlier today. Without further ado, I'm going to hand it over to Dr. Harris. He has prepared some opening remarks. Nō reira, kia koe te wā, Dr. Harris, tēnā koe.
Tēnā koe e hoa, e te kaiwhakawā, tēnā koe. Me hoki koutou ngā mema o te ropu whakamana I te tiriti o Waitangi. Tēnei te mihi ki a koutou katoa I tēnei ata. I'm just going to begin by summarising the thrust of my second brief of evidence and just make several points, I think 3, arising out of this morning's discussions. So the key point, I think, that I attempt to make in my second brief of evidence is that the amended principles, the amended version of the Treaty Principles Bill attempts to mirror the structure of Te Tiriti o Waitangi, but mutilates the content of Te Tiriti o Waitangi. The first proposed principle combines some redundant statements with an attempt to press the expansion of Crown power. The second proposed principle seeks to degrade, diminish, and even destroy tino rangatiratanga as it is guaranteed in Article 2 of Te Tiriti. And the third proposed principle distorts and narrows the protections that are given in Article 3 of Te Tiriti. In my view, the actions of the Crown since the release of Ngā Mātāpono clarify the real purpose of the bill. So the actions taken together reveal that the rationalizations that have been put forward by the Crown are just that, attempts to make rational or to make sound rational what is destructive. And so the rationalization of a constitutional conversation does not sit well with a process where no meaningful engagement has occurred, and it does not sit well with a process where one side of the partnership controls the terms of the conversation. The rationalization of this bill addressing uncertainty does not sit well with the fact that no attempt appears to have been made to engage with the tribunal's findings that there is tolerable certainty in the meaning of the principles and Te Tiriti o Waitangi. And it does not sit well with what Mr. Chana in his evidence acknowledges would be a new period of uncertainty created by the passage of this bill. And finally, the rationalization of equality, the idea that the policy problem here is equality, does not sit easily with a slight acknowledgement of rights of iwi and hapu in the proposed second principle, an acknowledgement that shows the emptiness of the claim that any protection of Māori rights is unacceptable from the perspective of equality. In terms of the process that has been revealed, by the materials. What I've said in my brief is that the attempt at a small number of conversations with experts does not merit the term engagement. And I'm just picking up on a point that was raised this morning as well. I've said that the phrase "as soon as is practicable" in the coalition agreement, that commitment to introduce a treaty principles bill as soon as is practicable, which means what can be done, should be interpreted by a responsible and honourable Crown as including constitutional considerations. So in process and in substance, I've said that the amended Treaty Principles Bill and the process underlying it amount to ongoing and further breaches of the principles of the Treaty of Waitangi and Te Tiriti, including Kāwanatanga and Tino Rangatiratanga, that there is also clear prejudice, as well as departures from norms of sound public policy and good government. And taken together, what's occurring here is an attempt to erase one of the treaty partners in full, both through the process and the substance. Just to touch briefly on several points that were raised earlier, there was a question raised, I think, by Dr. Phillipson about the coalition agreement and the role of Te Tiriti o Waitangi and its principles in the development of the coalition agreement. The relevant materials are before the tribunal, but I think it's worth noting that the Cabinet Office, the Secretary of the Cabinet, as you know, produced a circular following the finalisation of that coalition agreement. In my view, that is an opportunity to bring to attention threats to Te Tiriti o Waitangi and its principles, and that is a place where Te Tiriti o Waitangi can clearly be raised in relation to the coalition agreement. The second point I just wanted to touch on was the question raised by the Chief Judge about the English Laws Act 1858, and I only wanted to endorse the suggestion that it is possible to say that parliamentary sovereignty applies only so far as is applicable to the circumstances of the colony. That's the words of Section 1 of the English Laws Act. And of course, that act has been applied by the Supreme Court, including in cases such as Takamore and Clark, in order to adjust the application of English laws to the circumstances of this place. Third, there was a discussion, I think raised by Ms. Kapua, about whether it is accurate to say that the UN Declaration on the Rights of Indigenous Peoples has no legal effect. And in my view, to say that the United Nations Declaration on the Rights of Indigenous Peoples has no legal effect can only be a coercive attempt forcibly to change what has been the status of UNDRIP in New Zealand law, given the references to UNDRIP in multiple Supreme Court cases, including Wakatu, Takamore, Ngāti Whātua Ōrākei, and I think others, and Professor Claire Charters has written about this, among others. And those were the only remarks I wish to make in opening, and I'm happy to address any questions.
Thank you for addressing all those additional points, Dr. Harris. All right, Dr. Grant Phillipson.
Thank you, Judge. Tēnā koe, Dr. Harris. You've really dealt with my questions in your opening remarks, except for one. And that's the same question I'll put to you that I put to Professor Willis, which is about the rights and privileges of British subjects and the idea in Principle 3 that those can be expressed solely as the right to equality. What's your view of that? Are there additional rights and privileges?
Yes, tēnā koe, Dr. Phillipson. In short, my view is that there are additional rights and privileges going beyond the right to equality captured in Principle 3. One way to think about this is simply in terms of the rights in the New Zealand Bill of Rights Act 1990. And in that document, something akin to the right to equality is in section 19. That is one of many rights listed in New Zealand law, which include freedom of expression, the right to liberty and security, the right to a fair trial, and so on and so forth. And so when the right to equality is viewed in that light, it's very clear that it does not capture all rights that exist in New Zealand law. Now, the question might be raised whether that is the same as the rights and duties or privileges of British subjects, but I think the point in substance remains the same, that Article 3 goes beyond the narrow protection of equality, and that therefore Principle 3 restricts and does violence to the content of Te Tiriti.
Thank you. And you mentioned the Bill of Rights Act and section 19, but the right to equality per se is not in that act, is it?
No, that's right, Dr. Phillips.
Do you know why?
Yes, this was discussed in the drafting of the Bill of Rights Act, and the white paper to the Bill of Rights has a discussion of this. The case law has, in substance, interpreted the right to be free from discrimination as conferring rights to equal benefit and enjoyment of the law. So one answer to your question is that in substance, though the language is the right to be free from discrimination, it protects equality. It should also be read in line with the Human Rights Act 1993, which focuses on further rights of equality.
And does that right to be free from discrimination, does that encapsulate the idea that every citizen has exactly the same rights and only exactly the same rights as every other citizen?
No, if I'm understanding your question right, what it refers to is particular precepts of equality and non-discrimination, but as Associate Professor Willis pointed out, I think it's clear across the gamut of New Zealand law and policy and broader society that people have to be treated differently sometimes in order to achieve equality. And in fact, that reminds me that Section 19.2 of the New Zealand Bill of Rights Act, I didn't expect to be talking about this morning, but Section 19.2 of the Bill of Rights is an express affirmative action provision. And that is one acknowledgement in the law that equality is to be achieved through treating people differently on occasion. And I endorse what Associate Professor Willis said about it being a basic precept that different groups enjoy different rights, including through signing agreements and compacts, of which Te Tiriti o Waitangi might be thought to be one.
Yes. Well, I asked you about it because you raised it, but I was thinking about that earlier and thinking, for example, the rights of veterans, they're partly encapsulated in legislation, and I'm wondering how far those rights that you're talking about are already encapsulated in agreements or legislation of the type that Principle 2 refers to. If you hadn't thought about that, that's okay. But if you had thought about that, do you have an answer?
I just want to clarify the question. So is the question how much different rights from agreements are captured by the existing wording of Principle 2?
More that you've said that people have to be treated differently to achieve equality. And you mentioned some examples, and I'm wondering to what extent that is done through legislation or agreements and covenants you referred to, as opposed to them having those rights inherently, regardless of whether they're enshrined in legislation. Because Principle 2 says Māori can only have the rights that are either enshrined in legislation or enshrine might not be the right word because legislation can be repealed, but are either in legislation or in agreements with the Crown.
I hope this answers your question, but I'm happy to elaborate if it doesn't. My starting point would be that in order to achieve that ideal of equality, people do need to be treated differently. That is expressed in the law, across the law in different ways. And my reference to agreements was the thought that every time parties contract, different bundles of interests and rights are transferred and guaranteed.
Yes.
And just for the sake of completeness, I just reiterate what I say about Principle 2 in my submissions, which is that that to me attempts to freeze only the rights granted by the Crown at a particular point in time, namely 2024, and falls far short of Tino Rangatiratanga in Article 2 of Te Tiriti.
Yes, thank you very much, Dr. Harris. That's all my questions. Thank you, Judge.
Thank you. Mr. Derek Fox.
No questions from me. Thank you, Judge.
Thank you. Dr. Suter.
Morena. I just have one question about, following on from the question asked by Dr. Phillipson about Article 3. When I was interviewing Māori Battalion veterans in the 1990s, well, one thing I came to understand is that, well, I was told that being Māori in this country is about to fight for equality, and that the Māori participation in 2 world wars were premised on Article 3 of the treaty. Largely the duties and responsibilities that come with citizenship, and that the motivation of Māori leaders in Parliament at the time to create a unit based on ethnicity was exactly that, to fulfil their obligations and duties as citizens of this country. And as I listened to the questions and the discussion from a legal standpoint, I wonder if part of the problem for our politicians is that either they don't have access to historians or they don't understand the history of this country in terms of the Māori fight for equality. Would you agree?
Morena, Dr. Suter. In short, yes. And I'm not an expert on the law on veterans, but I think there is a broader point there that people are differently positioned in their lives because of what occurs to them, including because of what the state does to them, or because of what has been agreed, and rights are extended and affirmed in different ways in order to try to achieve equality. And I can only endorse what you said about understanding that history being so significant.
Kia ora.
Professor Williams.
Tēnā koe, Dr. Harris. Nau mai ki tēnei kororo i tēnei wā. I'm asking a question about paragraph 22, in which you were talking about the second amended principle amputates Tino Rangatiratanga as at 1840 and severs from Hapu and Iwi their expression of Tino Rangatiratanga in the future. So there's a bit of a medical metaphor there about amputation and severance. And what I'm trying to get clear for myself and others on this table is that the first set of principles that we saw from the ACT Party policy purportedly derived from some kupu Māori taken from the articles of the treaty. Now they're not there anymore, and I'm wondering if we're mistaken in looking at these principles as in any way related to the 3 articles of the treaty. There are 3 principles here, but you're saying that they've amputated key elements of the treaty articles in expressing these opinions. But perhaps it is the case that these are unrelated at all to Articles 1, 2 and 3, and they're just three principles that the Cabinet has approved for going into this bill. And it's got nothing to do with amputation at all. It's just coming up with their new version of what they want to call principles, which is a post-1975 term. It's got nothing to do with 1840 whatsoever.
Tēnā koe, Professor Williams. I think two things can be true at the same time. First of all, that in substance, what is in the principles proposed here has nothing to do with the substance and meaning of Te Tiriti. That's the first point. But that secondly, there is an attempt to mirror the structure of Te Tiriti, and in my view, that makes this bill all the more damaging because that faint mirroring of the structure undermines both the standing of Te Tiriti and the understanding of it. And I cite as a footnote a public comment made by Mr. Seymour where Mr. Seymour recounted what the treaty means and said the treaty means 1, 2 and 3, 2 being tino rangatiratanga for everyone. And I think that is why it's so important for this tribunal to remind us all what Te Tiriti says, how this is an amputation and how in substance this is unrelated.
Right. Do you have anything more to say? You in paragraph 24, you talked about common thread of degradation, diminution and destruction, and you sort of slightly apologise for the word destruction, but you nevertheless want to stick with it, do you?
Yes, I don't apologise. I just say that I don't use the word lightly, but that tino rangatiratanga was a guarantee of ongoing expression in Article 2, and that's why I use the word amputation. There's an attempt to whittle down what that means, to freeze it, and that, to me, does degrade, diminish, and to destroy tino rangatiratanga.
Okay, thank you. So can I just put the same question that I put to Ms. Natalie Coates, referring to paragraph 30 of Mr. Chana's evidence that senior officials of the Crown thought that they were attempting to mitigate to a limited extent some of the concerns that have been raised. Do you see that that is the case, or do you just have any other comment to make?
I think I made the point in my brief that these principles should not be taken to be mitigating that damage in any way or that difference. I think that difference is acknowledged in the evidence of Mr. Chana. I also think it's worth noting that if I'm remembering rightly, that reference comes underneath the original proposal from the Crown, which did include a reference to the positive duties of the Crown, which went a little further, and that reference to the Crown having positive duties to Māori, to iwi and hapu, clearly has now been removed. So I think there's no basis for the tribunal to conclude that any of that difference or damage has been mitigated. And I add that I think Ms. Coates uses the word amputate as well, and we hadn't seen each other's briefs before, both using that description.
You're suggesting the great minds think alike?
No, it's just that it's not.
So that's not a question.
Reasonable. It's not unreasonable for a person to reach that conclusion, and that just our minds reaching that conclusion, and I'm sure others would reach the same conclusion, and many have.
So just a question about, you comment paragraph 27 and 29 about the failure of the targeted engagement with experts and the failure to provide an exposure draft. But unless I've missed it, you haven't said much or anything about the Cabinet decision to give a full 6 months for the Select Committee inquiry. Is that something you've turned your mind to?
Yes, and maybe I can address it now, since I didn't address it directly in the brief. The first point on targeted engagement, as I've already said, is I don't think the attempts at conversations merit the phrase targeted engagement, and I think being direct in our language when there are constitutional threats is very important. I don't think the 6-month Select Committee process can be taken to outweigh or compensate for the lack of consultation, in particular the lack of engagement with Māori over the course of this year. There has been time, and I think what's very important is that if a party is having a constitutional conversation, the terms of that conversation should not be controlled by one party or a small political party. And there were opportunities this year for the terms of that conversation to be carefully and fairly established. That opportunity was not taken up. And I think that shows that, as Ms. Sykes said, this rationalisation that the policy problem was the need for a constitutional conversation is really a sham. To me, other steps would have been taken, including taking up the Crown's offer of how to have a constructive constitutional conversation, including through the provision of information and education prior to a Select Committee hearing, if the purpose of that hearing was genuinely to have a conversation as opposed to pursuing political ends.
So can I just reframe a question? Because what I was wondering was what your opinion might be of the fact that the Cabinet agreed to any length of Select Committee hearing at all. If two of the parties to the coalition are not going to vote for it to continue, Cabinet could have decided to have a 1-week Select Committee hearing, or even no Select Committee hearing. They could have just decided to have a first reading debate and vote for it there, and then have a very short reference to a Select Committee. But they've given 6 months to a Select Committee. Does that sound good or bad to you in terms of your analysis of the policies?
Sorry, thank you for clarifying. I think it's profoundly damaging. And I think I mentioned in my brief the responsibility of the Prime Minister in this context and the responsibility of the government as a whole, not to perpetuate misunderstanding of Te Tiriti and degradation of Māori rights, and to allow that period of Select Committee consideration on such a dishonest and disingenuous basis, I think is irresponsible, and makes more likely that future generations of people and communities will continue to carry faulty understandings of Te Tiriti, misunderstandings of the rights guaranteed by Te Tiriti, and harm may follow from that, including the justified insecurity that has been expressed by many Māori in having to engage in this conversation.
That's very helpful. Thank you, Dr. Harrison. Thank you for becoming available for the Tribunal at short notice, and thank you to the Claimants Council for arranging for that. Kia ora.
Mr. Prime? No questions? All right, Ms. Kapua.
Thank you, Dr. Harris. I just had a couple of questions which are not specifically on paragraphs in your evidence, but I just wondered if you would comment on the view that this bill is defining treaty principles as how it's described. And yet we have, as you refer to, I think, a mirroring of the structure of Te Tiriti in terms of what this bill interprets as principles. So just wonder if you have a comment on where does that actually leave the jurisprudence around principles in relation to Te Tiriti, if this mirroring goes forward and how that sits with the articles versus the principles issue.
Ms. Kapua, thanks for that question. There's several ways of answering that question, but yeah, the question is, where does this leave the jurisprudence? I do think that the jurisprudence has been tending towards affirming tino rangatiratanga and kāwanatanga as principles in the courts, as I say in my brief, as well as a result of the tribunal's work. And there are ways in which other principles can be related to those words of Te Tiriti. So principles like active protection, referring both to Article 1 and Article 3 of Te Tiriti, for example. That's just one example. But in my view, a question might be raised whether this bill has been introduced at a time when we were getting closer to the text of Te Tiriti through the work of the tribunal and the courts and others, and that text having its proper legal effect. But to come to another way of approaching that question, I think this bill, if passed into law, would create significant uncertainty for the courts. The courts try to understand the body of the law as a whole, so they would try to fit in the Treaty Principles Bill just as one single statute into the broader framework of the law. And that this bill will make some claims about what the treaty principles are. But I think in the spirit of your question, it might be open to courts to hear argument about how these are not principles at all, and these do not sit at the same level of that jurisprudence that I've referred to earlier. But it may also be open to courts to try to fit together the Treaty Principles Bill and that past jurisprudence. What I think is very clear is that the supposed policy problem of certainty is not advanced by this bill. And I have, I think, had that same thought that are we better off to refer to these principles in this bill as David Seymour's maxims or slogans, given that they do not, I think, sit at the same level as those other principles that bear some resemblance to the text.
And would that be affected by the fact that the legislation that is being sought to be clarified, for want of a better word, is legislation that uses the term principles?
That creates significant confusion, doesn't it? The legislation claims to be addressing the same subject matter that the courts have been addressing in the past. That answers your question.
Okay. And just finally, obviously from the evidence that we've heard, there's a lot of criticism about the way in which what's being proposed conflicts or has a tension with constitutional arrangements, with the way in which, with the limitations as they exist in relation to parliamentary sovereignty, with the way in which international treaties have been regarded and so on. What, in your view, are the options available for any kind of challenge where, as we've heard, the government has gone beyond what would generally be accepted as reasonable constitutional lawmaking in these circumstances? What is available to people to take it to the next step?
Pātai pai tēnā. I'm aware of at least one master's thesis that has already been produced on the Treaty Principles Bill possibly being subject to a challenge that it goes beyond Parliament's lawmaking powers. I think it's difficult for me to say in the abstract what the prospects of success would be for that kind of challenge. But I think it is plain that this bill, if passed into law, would amount to a structural breach of several aspects of New Zealand's constitution. And I've looked in the past in an article published in the New Zealand University's Law Review some 10, 15 years ago at different possible bases for judges striking down legislation in New Zealand, even though that has not been done and is generally seen as unorthodox. And those bases include using Te Tiriti o Waitangi, using Section 4 of the New Zealand Bill of Rights Act, which says that essentially no enactment can be struck down by reason only of an inconsistency with the Bill of Rights, as well as arguments, as well as other arguments about fundamental constitutional breaches. And it's worth noting that in both in the US and in elsewhere, powers to strike down laws were inferred by the courts in moments of constitutional crisis. Without going too far down that path, I think it's worth just saying Parliament is navigating very treacherous waters, including legal waters, the further it proceeds with this bill.
Thank you, Dr. Harris. Thank you for your evidence.
So, Dr. Harris, I too, like my colleagues, want to thank you for making your time available again at such short notice too, again, and an extremely helpful brief. At page 6, you just outline again the principles. And as you've noted, they've changed from what was in the Act policies, although there's an attempt to keep them reasonably consistent. But the fact that they have changed indicates that the coalition agreement can be changed with goodwill on the side of both parties. And a responsible Crown, would you say, would recognise that while this is an attempt to make the Act policy better or improve it, it's still not consistent with either the existing principles of the treaty and or the text of the treaty. Would you agree with that?
Yes, I would agree. And I think there are two important parts of the coalition agreement that arise out of your question. One is, as soon as is practicable, as I've already said, what is practicable, what can be done, should also mean what constitutionally can be done. And if it's not possible without fundamentally breaching aspects of New Zealand's constitutional arrangement for a policy to proceed, I think it's imperative for the Crown to point that out. But the second part is, I think the reference in the coalition agreement is to a policy based, is to a treaty principles bill based on Act policy, and based on allows some room to move, as you say. It shows that there can be some departure from that to ensure constitutional consistency. I'll just add one further point, because it was a point raised earlier about prejudice under this version versus the previous version, and a question posed to Ms. Coates. And my view is, in some ways, this version can also be seen as particularly insidious because it is quite precise in what it extinguishes. And so the vagueness of the earlier formulation, the reference to chieftainship of all New Zealanders, which would have been read subject to the existing law, in some ways was at least subject to further judicial safeguards. But there is more specific extinguishment, freezing and degradation of Māori rights in this formulation, which I think can be pointed out.
Well, that's important to note. And if you look at Principle 1 And the fact that, as you say in your paragraph 26, the wording reflects what's in the Constitution Act 1986. And if we go back to the issue of the English Laws Act of 1858, which is now the Imperial Laws Act, correct? You know, it's now been, it's still on our statute books, but it's called the Imperial Laws Act, I think. Professor Williams will correct me if I get it wrong. Anyway, what we discussed at morning tea, and I just want to run this past you, is if the 1852 Act recognised, if the treaty has to be taken into account in terms of the circumstances of the colony, then the 1852 Act has Section 71, which created native districts. There's a recognition of power sharing in that constitution. That's not reflected in the 1986 Constitution Act. That particular provision is taken out, it's repealed. But do you have anything to say, as we've already articulated to some degree in Chapter 2 of our Mātāpuna report, that despite the fact that you might have full power to govern and make laws, you can only do so to the extent that is constitutionally permitted or constitutionally recognised or constitutionally acceptable, subject to the constraints that are imposed upon doctrines such as parliamentary sovereignty. So, to the extent that that may be true, how does Article or Principle 1 detract from what is the principle of kāwanatanga in the current jurisprudence relating to principles?
There are a few points I want to pick up from the question, but to take your last question first, I think the first principle is also an attempt forcibly to distort the meaning of kāwanatanga as it might be taken to be expressed elsewhere in the law. And as you also point out, if this were to pass into law, this would be read against the backdrop of that broader law. But this attempts to enforce and elevate the powers of the Crown. And this is another point I wanted to make, is that it's important to analyse each of these principles in isolation, but it's also important to analyse the interrelationship between these principles, as well as the interrelationship between the Articles of Te Tiriti. And the article and Te Tiriti involved a solemn exchange of promises and a careful balance of authority being struck, which involved each party's sphere of authority being respected. And this distorts that balance in the extreme by trying to lift the Crown above by repeating those parts of the Constitution Act. And of course, I wanted to mention, I'll just pick up on what you said about Section 71 of the Constitution Act. And I know you and myself and Professor Williams and others will be more expert on this than me, but I believe it's the Native Exemption Ordinance, I think 1844, and also Residence Magistrates Court Ordinance early on. And I only mention these as examples.
1858.
That's right.
Isn't that right?
I defer
He's
to you
nodding
on
his head.
The practice of native assessors, which allowed Māori assessors to act as judges. I mention these because they reflect an understanding at the time of shared authority, just to build on your point, and reflect the understanding of tino rangatiratanga at the time, which is so clearly being upended by this bill.
Yes, it's interesting. So if the government of New Zealand has had full power to govern and the full power to make laws, this doesn't take away from the fact that it must do so in accordance with the pattern of government that was set at the time the treaty was signed and reflected in subsequent legislation and in the Constitution Act of 1852. And even though Section 71 was taken out in 1986, there's still enough in the legislation to demonstrate that recognition of shared governance.
That's right.
Is that what you're saying? I just need to understand it in order to decide how this discussion should be reflected or not in our report. Now, have you ever looked at Section 18 of the Māori Community Development Act?
I'm not sure I have, to be honest.
Oh, that's okay.
But,
well, Section 18 sets out that one of the roles of the New Zealand Māori Council is to foster and encourage local self-government, or words to that effect. I haven't got the words in front of me, but that would seem to suggest that local Māori self-government has existed and still exists today. Whether you agree with the New Zealand Māori Council or not, would that be captured, that type of provision, by Principle 2?
It's difficult to say.
Can I put that? Can you think about that and provide a written answer?
You're very happy to. It might be covered by the reference to where those rights are specified in our legislation, but I think that raises the uncertainty of Principle 2. And I think just trying to summarise, as you invited me to the discussion, I think what I would say is that any narrow proposition in a single statute, such as the Constitution Act, or the Treaty Principles Bill about Parliament's powers to make laws, will always have to be read against the backdrop of the broader law, including other references in legislation and Te Tiriti o Waitangi itself. Just to make a further comment, I mean, it's clear that this statement in the Constitution Act about the full power to make laws is already subject to implicit constraints, in the sense that it's generally accepted that judges make law through developing the common law. And so Parliament's full power to make laws has to be read subject to that other aspect of our constitutional order. There are other...
That's exactly right. So what's the point of it?
That's right.
It's not what Article 1 in the English or Māori version of the text of the treaty says. It's not it's already declared in the Constitution Act of 1986. So what's the point of it?
That's right. And especially given the significant cost, I think the fact of some redundancy is worth pointing out. And I make the point in the brief that these principles manage at the same time to be redundant and a fabrication.
Yes, and we all know that the text of the treaty, Article 2 of both the English and Māori version, doesn't reflect what's in Principle 2. You'd agree? And likewise, Principle 3 is no reflection of what's in the text. So they're quite separate and distinct. then we go back to the point you were discussing with Ms. Kapua, that and I'm sorry to take so long to articulate this, but it's quite important. So the fact that the principles are divorced from the text, have nothing at all to do with it, and are divorced from the jurisprudence relating to the principles of the treaty, but sit outside and have no purpose whatsoever other than to state a position of political propaganda, if you like, then how can the Crown be said to be acting consistent with the principles of the treaty?
I entirely agree with the thrust.
Principles and even with the text. You can take it one or the other.
I agree with the thrust of the question, and I think it's open to the tribunal to say that these principles are so divorced from the text and the jurisprudence that they do not merit the label principles, at least in the sense that principles have been hitherto understood, and that any responsible and honourable Crown would at any point insist on.
Thank you. I think I've overstressed the point, but I'm slowly understanding, I think, where we're getting to with these three principles. So thank you very much, Dr. Harris. I'm just going to ask Mr. Allen if he's got any questions to follow up on anything we've asked.
Thank you for asking, Mum. We have no follow-up questions.
All right, Dr. Harris, again, I thank you so much for your time and the effort that you've put into assisting this tribunal. As you know from our report, your work was fundamental to some of our findings, so thank you.
Thank you.
So thank you, everybody. We're now at the point where we can move into hearing from Mr. Allen with the Crown's opening, and then we'll hear from Mr. Chana after lunch. No, before lunch. Lunch is at 12:45. So let's start. We do have a large number of claimant lawyers who want to question Mr. Chana. So it's actually quite useful that we've ahead of schedule.
Thank you, Ma'am. We have filed, as Your Honour knows, a very succinct opening address in which we note that this hearing affords the opportunity, the tribunal rather, the opportunity to apply the analysis contained in Matapono to recent developments. And we'd like to acknowledge, as we do in our written opening, the work of the tribunal members and staff in urgently accommodating the hearing, and to also formally record that we appreciate the significance of these matters to claimants and interested parties, as has been reflected in the opening submissions and the very erudite evidence that we've heard from the three witnesses this morning. The Crown's role we see here in this hearing today is to support the tribunal's continued inquiry by offering the evidence of Mr. Chana. And as we say in our written statement, Ma'am, Mr. Chana will provide to the tribunal an overview of the advice given and the decisions made on a range of matters since the tribunal last had an opportunity to consider policy steps and decisions taken at the last hearing. We summarise those matters, or the key matters that he speaks to at paragraph 8 of our opening, namely issues related to the timing for progressing the draft bill to introduction, the efforts of the Crown to engage a small group of experts on the drafting of the principles, the thinking behind an approval to a revised set of principles which we have been considering this morning, and also Mr. Chana can speak to the work required to scope the potential effects of the proposed principles on settlements, settlement negotiations, and other legislation. So those are the only matters I wanted to say by way of opening comment, ma'am. Now, Mr. Chan is seated behind me, which might make his image a bit small, and I wonder whether we might just have a moment where he could just swap briefly with my friend.
Yes.
And assume a bit more prominence in the screen.
We will just ask you some questions first and then ask him to move. That'll be very great, helpful for him to move. Dr. Phillipson, do you have any questions?
Sorry, takes so much effort to turn off the mute. No, thank you, Judge. I don't have any questions.
All right. Mr. Fox?
No questions, thanks, Judge.
Professor Williams? No questions. No questions. My only question, Mr. Allen, is I assume because you've had no questions that we can take all the evidence that's been provided as evidence that you've accepted?
The evidence that we've heard from the experts, ma'am?
Yes, this morning.
Yes, I mean, it is all expert evidence that the tribunal is entitled to take into account. It is all relevant evidence addressing the issues before the tribunal. We have no issues with that at all.
Thank you. All right, that's my only question. All right, Mr. Chana, come forward. Thank you. We use it for court.
Trade. It's probably one, yeah. No, give it a go. Maybe turn the camera off. Maybe turn it back on. Right.
Welcome back.
Thank you.
Good to see you, Mr. Chana. Thank you for making yourself available again.
My pleasure.
When you're ready, you can just give us a short overview of your brief, just so everybody at home knows what we're dealing with here.
Okay, I'll keep it very brief since there are a number of people wanting to ask questions, but in general what my brief provides is an overview of what has occurred since the last hearing and the evidence provided to this tribunal. So I just skipped through the briefings that have been provided through July and August in particular, which sets out the more detail of the process of the development of the Cabinet paper and the regulatory impact statement, which was subsequently decided upon. And I think that's probably gives you the high-level overview. And the other aspects I can also speak to and will cover is in relation to the referendum provisions as well, which I think was specifically asked for. So that's the other aspect in terms of the commencement aspects of it and how that might work.
Thank you. And did you get a copy of the article that I had circulated and put on the record of inquiry this morning?
Yes, I've had a look at that article.
And are you familiar with the select committee process?
Yes, I am.
And so if this bill goes into Parliament on the 18th of November, as predicted at this point, how long will it take before a select committee is convened?
So I understand the proposal is to refer it, the natural committee to which it will be referred as the Justice Select Committee. So it wouldn't require the convening of a new committee. It would be referred there. Standard practices after first reading, it's referred to that committee as part of the motions approved in the House. and at its next available meeting, the committee would then most likely call submissions and request advisors to be made available in other administrative matters. So that's usually in the week following the first reading.
Okay, and so how long does it take usually for the call for submissions? What length of time are people given to provide submissions?
Default is usually around 4 weeks, but it's up to the committee to decide what it thinks is an appropriate period of time to leave open for submissions to be made.
Okay, and when does the Parliament rise for the end of year?
I've handily moved along my sitting calendar, just a moment. The last sitting day on the calendar is this Thursday, the 19th of December.
Okay, so the select committee
it may rise a day or two early.
Okay, thank you, that's helpful. So the Justice Select Committee probably won't get to hearing submissions on this bill until next year?
Practically, I wouldn't expect them to be able to do anything of that sort, no.
And what month would that be?
In terms of the new year?
Yes.
Or,
yes. What would be the earliest time it could start hearing submissions?
So if they were to allow the normal 4 weeks period of time for submissions, that would close basically in the lead up to Christmas. And then in terms of the House sitting again in the new year, a sitting program hasn't been confirmed by the House, but typically the House would sort of convene in the first week in February after Waitangi Day is usually when the House would reconvene. And so the earliest available opportunity would be in February, mid-February.
All right. So in real terms, then there'll only be a 4-month period for hearing submissions.
Yes, the proposal is that the committee would report back in mid-May next year, and so then you'd have February, March, April, and that part of May for it to hear submissions.
All right, thank you. And in terms of an overall estimate of the costs associated with that process, both in terms of the PCO costs and the select committee costs, do you have any idea of what the costs would be?
No, short answer. Typically, we don't generally are in a position to be able to cost how much it takes for us to produce a single bill and take it through the parliamentary process. In terms of how we are set up, we have an appropriation in the budget for my group, which is the policy group, which works on any number of bills that are prioritised by the government, and similarly with the Parliamentary Council Office, they allocate resources from their budgeted pool of resources. So we don't timesheet or keep any detailed records which will enable us to come up with an accurate costing of what it might be. And in broad terms, a bill of this nature, a number of people would work on it, but you would kind of say at any given time, you might say in terms of full-time equivalents, you may be having 3 or 4 sort of working consistently through on it, but then that probably doesn't count my time, secretary's time, and sort of the broader input that has into it. But principally, the key cost is in terms of opportunity cost of what we might otherwise be expending our capacity and working on.
So this estimate here of 4 million, you wouldn't say that it wouldn't accurately reflect?
No, I don't know what basis on which they've calculated it. I would love to have 12 people working on each bill, but that's not the reality at all. But if you're looking at across all of the departments, I mean, in the cabinet paper we indicate who we've consulted with, so there'd be people's time from those departments as well that would have worked on it. So it's very difficult to come to any sort of strong conclusion about what the cost might be.
So if anything, it's an underestimate?
Not knowing what's made up in that $4 million, I couldn't sort of really offer a comment.
All right, thank you. Can we now hear from Ms. Sykes? I think you've asked for 10 minutes.
Might be more than 10 minutes after that opening, but kia ora. Kia ora, Mr. Chana. Lovely to see you again. If there's any problems with us, please let me know, hearing each other or me interrupting you inadvertently. My first question, and you were here Dr. Harris's evidence, and it really arises from what he said. When you interpreted the coalition agreement's reference to the need to introduce the treaty principles bill as soon as is practicable, do you agree that what is practicable, what can be done, includes constitutional considerations?
Well, it includes a number of considerations, but I'd probably just highlight at the top end, as soon as practicable was what was agreed between the parties. And in terms of setting the timetable, that's the matter for the Associate Minister in consultation with his ministerial colleagues. And if I go back to the original briefing we provided to Minister Goldsmith in December last year, that was us trying to get some scope and understanding of what they meant by as soon as practicable, and that's why we've had a number of iterations of different timetables to surface what that might mean for them.
So would you, though, in your experience where that term practicable, because you didn't answer the question, include constitutional considerations in assessing whether that has been that qualitative measurement?
Yes, it'll be one of the considerations, and I think that's highlighted in our advice in terms of we lay out what are the things that might be needed in terms of the different timetables that we were proffering.
We accept, my claimants, that you are in quite a difficult position. The Prime Minister has said that the National Party won't support the bill passed Select Committee. The Associate Minister, Seymour, wants you to prepare for the legislation to pass, including to prepare for a referendum. How did you interpret those contradictory signals? How did you deal with those matters?
Well, our guiding principle is what Cabinet has decided, and as recorded in the Cabinet Office circular of March of this year, the coalition agreements form the basis of government, and that circular also says that ministers and departments are to do what's necessary to implement those. So that is our overarching construction, and the coalition agreement says it was to introduce a bill and refer it to Select Committee as soon as practicable. So in terms of what other commentary might have been around it, our key focus is on working with the Associate Minister, who was delegated a responsibility to fulfil that coalition agreement and take it through the Cabinet process and through to a first reading.
So what reason did the Associate Minister provide for abandoning the original intention of circulating an exposure draft for public consultation?
We didn't get any particular. We provided a draft Cabinet paper for his consideration, and then that was, as we understand it, subject to consideration within his office and also ministerial consultation. And then, sorry, I just need to refresh my memory on all of the very many dates. That's right. And then simply, it was on the 22nd of December, that's in paragraph 10 of my brief of evidence, that we were informed that the Minister was considering a shorter and more targeted consultation period. So whatever they discussed and whatever they considered, we were then informed of that and asked to then take that forward.
What reasons has the Associate Minister given for not engaging with Māori as part of this targeted matters up to this point?
I have no particular reasons. Most of it seems to be. There were two aspects to it. If I go back to the earlier evidence provided, which was around the policy was the policy, and then the engagement that we had discussed previously with the Minister was out in the context of an exposure draft, which is not on the policy underpinning the bill, but was more about how that policy is expressed in draft legislation. And in terms of consulting on the policy, the essential backdrop to that is that it was set. It was the coalition agreement had set that was the policy that was to be pursued. So engagement was with on the drafting of the bill, and then within that was the practicalities of the different time periods that were slowly reducing in terms of availability, and who it is that you could meaningfully engage with or talk to in the times that were available.
The proposal to speak to a small number of experts when there really wasn't time to, after the draft bill, in light of those conversations, really merit the term engagement?
I don't see any particular term of art there. Is that we were seeking to be able to engage with people on the drafting. The content of what we might engage with has sort of shifted over time as the time available has shrunk. And as we note in a number of places, we do highlight the fact that the engagement would not be satisfactory to some, or would be very limited in scope.
Just to enlarge a little bit on that, the documents indicate that you reached out to a number of experts, presumably from the list that was annexed to the document to the Minister of a letter of the 29th of July. Was everyone approached on that list?
I'm afraid I don't have specific knowledge on exactly how many were approached. Some, in the context of the names we provided to the tribunal, had already contacted us subsequently to say they weren't available or did not wish to participate. So I don't have specific knowledge to hand regarding exactly how many were approached.
How did you select those that were approached? What was the criteria of acceptability?
We'd outlined in that brief on the target engagement where we'd kind of gone through some qualifications in coming up with the list of people. And then for us, it was just a case of working through the list to determine who might be available and willing to participate.
So who ended up being willing to participate, or who ended up doing it?
In the end, as we kind of summarise in our briefing of 21 August, I think we had a small number, maybe 3, who might have been willing to come to a meeting on the 19th of August, but subsequently we had no one attend that, given sort of once we clarified the nature and scope of the exercise, no one really wanted to participate.
So there was no one?
Oh, no, sorry. Forgive me, one person that did attend, but on that basis, we didn't really consider that to be engagement, and the purpose of the meeting wasn't fulfilled.
Okay. Can I just, when you confirm, I just want to confirm in your evidence that the amended principles do not align with the Te Tiriti o Waitangi properly understood. You said that previously, and you said it in this brief. Can you confirm that that continues to be your position now?
Yes, no, we've said that consistently through our advice, is that the alternative wording does not accurately reflect the articles of the treaty.
Or Te Tiriti itself?
Yes, yes.
Has a further regulatory impact statement been prepared? And if so, what has it concluded in terms of the new articles?
So the regulatory impact statement that we provided, that's been provided to the tribunal, is the only one. What we've been referring to in the lead up to finalising the cabinet paper, we had various iterations which were tagged the interim ones, which have been updated as subsequent decisions made. So the regulatory impact statement that you have is the final version that was concluded in light of all the proposals in the cabinet paper that were submitted.
Your counsel just said this, you just said in question, answer to Chief Judge Fox, that the Select Committee will be referred to the Justice Committee. We're wondering why it's not the Māori Affairs Committee or a specifically convened committee. Can you just help me, or is there any likelihood that there'll be a specially convened committee? And I'm saying that in the context of, for example, some of the other kind of special engagement that occurred on significant matters, like what is in iwi and the Fishery Select Committee process and those matters.
So what I was saying there was that a Justice Portfolio Bill is ordinarily referred to the Justice Select Committee, and so I have no indication that it will be referred to a specialist committee or any other committee, and the default would be that it goes to the Justice Select Committee.
Is it your understanding that the Select Committee will hear submissions primarily in Wellington, or will they travel the country? Have you heard anything like that or considered that, given the nature of the particular subject matter?
No, I wouldn't expect to know that. That we'd only know that once the committee has seized of the matter, and it's then up to the committee to determine its procedures, and we would engage with them at that point.
Given your preference that the Associate Minister's preferred timeline would constrain the time for parliamentary drafters to prepare the legislation, did you discuss this advice or raise your concerns with the Attorney General?
No, we did not directly raise that with the Attorney General.
What are the implications of a truncated period for the PCO to perform their role in drafting the legislation?
Well,
and for the record, Parliamentary Council's Office, PCO. Sorry.
Yes. In terms of developing these timetables, we have always been speaking to Parliamentary Council Office regarding what they would need and what time they would need to do the work that they need to do. I suppose the only comment I can offer is that the truncated times does limit their ability to consider all the different matters they need to in drafting, and that has a subsequent impact on the quality or the depth in which various issues could be explored prior to finalising the bill.
Okay. When the Crown says in its submissions that the inquiry should be retrospective in its focus, and I'm talking this inquiry, do you agree that the Crown cannot close its ears to the further findings of the tribunal and is capable of adjusting its approach based on the findings of the tribunal? No, I just think it's really important in the context of this inquiry where we've had interim findings and now we've got this further stage with the specific information that we'd requested earlier only now being provided.
So I'm not sure the reference to retrospective. What's in the
That's in your Crown's opening submissions. That's your Council's opening submission.
Oh, yeah. What do we mean by that?
Yeah. In the context of privilege over PCO.
Didn't ask your counsel to give evidence, I'm asking you.
Yeah. Hang on. Just hang on. So we've got the submissions.
Which paragraph of the opening submissions is it in the site?
Yeah, to get them open again.
Five.
It's number 5. I'll read the question out into the record if that will help you, Dr. Phillipson. At paragraph 5, the Crown notes that although the decisions now subject to this resumed inquiry are those taken only since the last hearing, they are nonetheless decisions already taken, and as such, the inquiry is retrospective in focus, and I'm exploring that matter with this witness. And just to repeat my question after that little interlude, Mr. Chana, when your counsel says in its submissions that the inquiry should be retrospective in its focus, do you agree that the Crown cannot close its ears to the further findings of the tribunal and is capable of adjusting its approach based on the findings of the tribunal?
Yeah, well, my understanding is that obviously we are looking at decisions that have already been made, but whatever findings the tribunal makes in the context of those decisions, we would certainly take into account and also raise with ministers, and I would expect would be something that we would raise with the Select Committee once it is seized of the matter.
Ma'am, those are all of my questions. Have I done it in 10 minutes? If I have, I'm feeling very self-congratulatory. Here I am able to do it. Still done.
Yes, very close. All right, Tāmaki Legal, Victoria Tumai.
Tēnā koe te kauwhakawā. We do have Mr. Redwood and Ms. Johns, and I know we have 10 minutes, but they will be executing the cross-examination. I'm mindful of the time you're on at 12:42. Were you wanting to still commence those questions now?
Yes, we're going to have lunch at 1 o'clock.
As Your Honour pleases, so the first councillor will be Mr Redwood, and then Ms Johns will follow if that pleases Your Honour.
Tēnā koe, Mr Shana. I just have a couple of questions for you. We'll go straight into them. Just making sure you can hear me properly.
Yes, I can hear you.
So in the cabinet paper, the document A27 at paragraph 18. Do you have that in front of you?
Yes, yep.
So the Associate Minister has stated that the word taonga is to be interpreted in accordance with the principle of equality. Does the Minister infer that the meaning of taonga will be limited to what the general population of New Zealand considers valuable?
I can't really comment on what would be in the Minister's mind on that specific point.
I'll just move on to the next question then. So mainly looking at the second proposed principle from the bill, just quickly to point it out, is the Crown recognises the rights of hapu and iwi have when they sign Te Tiriti. The Crown will respect and protect those rights. Those rights differ from the rights everyone has reasonable expectation to enjoy only when they are specified in legislation, treaty settlements or other agreements with the Crown. Just putting to you, this principle means that tino rangatiratanga only exists if it's legislated for, doesn't it?
Yes, and hence that's set out in our advice that sort of led up to the cabinet paper where we say that the tino rangatiratanga would be defined by koanatanga.
And so just going quickly to Dr. Harris's evidence, he stated that the bill would, quote, unmistakably seek to alter or amend the legal force given to the treaty. Would you agree, considering the advice you've given, that that would be a fair statement?
Sorry, could you just repeat that? You were saying I would...
Do you think that the bill would alter or amend the legal force that is given to the treaty?
Well, I'm trying to sort of sum that up in terms of all of our advice that we provided in it. We would say, yes, it would redefine the principles, and then that would mean that we'd need to revisit the interpretations and jurisprudence that has developed over the last 40 years. So it would ultimately result in a change, which we say then results in a degree of uncertainty as that's then settled again as it goes through the courts and tribunals. So it does involve a significant change by defining the principles in this way.
So would you accept then that in doing this, the Associate Minister is in effect rewriting the text of Te Tiriti via changing its legal effect?
No, I mean, I think if I refer to the cabinet paper, the policy intention is not to rewrite the treaty, and it's not to disrupt settlements, but it is to define in law what the principles are that will be applied. So that is what the stated intention and purpose of the policy is. So I couldn't agree that it's rewriting the treaty, but yes, it would involve changing the principles, which would then change the interpretations and approach taken to the jurisprudence that is developed.
Going back to your advice you gave to the Minister, it seems that kāwanatanga would be sort of elevated above te rangatiratanga, which is a divergence from what Te Tiriti itself says, isn't it?
Yes, that's our advice from the outset, where we characterised this as a novel reading of the treaty and the principles.
All right, I'm just going to move on to the final question. In the cabinet paper, the Associate Minister claims that under the Treaty of Waitangi, the government has the full power to make laws, but under Te Tiriti, but the applicable treaty is Te Tiriti or Waitangi, the Māori text, and because that was the treaty that was signed, wasn't it?
Sorry, where are you referring to in the cabinet paper?
At paragraph 14 to 16.
Yep. Yes, okay, and...
Sorry.
No, sorry, my mistake. I just wanted to know where you were referring, and I wonder if you can then sort of, what would you like me to comment on?
It's talking the minister's claims that the Treaty of Waitangi, under the Treaty of Waitangi, the government has the full power to make laws. Just first question on that regard, the applicable treaty would be Te Tiriti o Waitangi, not the treaty, wouldn't it?
We refer to both in our policy work.
So if we were to look at Te Tiriti, which affirms Te Rana Te Tanga, are you aware of the affirmation of sovereignty?
Affirmation of sovereignty made
under Te Tiriti.
Yes, yeah.
And given Article 2 of Te Tiriti, the minister cannot claim that he has the full power to make laws then, couldn't he?
Yeah, okay. That could be an argument, but I suppose in this context, that principle as drafted was referring again to what was in the Constitution Act. So that's, yeah, I'm not really sure what I can kind of commit to in that space, but under the current settings, and as I said, as others have commented, that is maybe a redundant statement, but it is drawing from the Constitution Act 1986 in terms of the position of the Government of New Zealand and the Parliament of New Zealand.
One final question. So we've heard that the Constitution Act has some limits as being prescribed by Te Tiriti. So you would, given the past question, would argue that the Constitution Act doesn't give Parliament the full power to change law as it sees fit, would you?
I suppose we're delving into the realms of expert evidence really here in terms of the others that had before you, and this feels like that consideration of sovereignty of Parliament and how far that extends. I suppose in my kind of starting point is the orthodoxy of parliamentary sovereignty, but there is obviously that developing consideration of what limits could be put around that, and I suspect that's something for deep consideration in the full constitutional inquiry before this tribunal.
Thank you, Mr. Sharma. I'll just hand over to my learned colleague, Ms. Johns.
Tēnā koe, Mr. Turner. Just have a few questions for you around the policy development timeframes, particularly regarding the alternative principles. You agree, wouldn't you, that your office and other agencies involved work to some pretty tight timeframes when developing the alternative wording?
Sorry, there's something about where your microphone is. I'm having a trouble making out exactly what you're saying.
I'll move to where my colleague was.
Yes, well, I've done that dance too, so yeah, I completely understand.
Hear me better now?
Yeah, no, that is better, thank you.
Awesome. So you would agree, wouldn't you, that your office and other agencies involved worked to some pretty tight timeframes when developing the alternative wording?
Yes.
And as a result of the tight timeframes, you'd agree that the usual robust analysis of the issues was possible?
Yeah, I mean, that's summed up, I think, in the regulatory impact statement in terms of the limitations are quite clearly set out there in terms of our inability to explore options and consult with others.
So would you accept that Cabinet was not fully informed and was in fact under-informed when it made decisions to proceed with the bill? Was under-informed about issues and the consequences that might result if the bill was advanced?
No, I'd say, well, because Cabinet is presented with the Cabinet paper and our regulatory impact statement at the time. And so the regulatory impact statement and its purpose is to highlight what all the risks, limitations, assumptions, and constraints that were on the analysis. So Cabinet had the proposals in the paper alongside our regulatory impact statement, and then it's a matter of judgment for Cabinet about what they are willing to decide based on that. But Cabinet was fully informed about the limitations of the advice that underpin the proposals.
At paragraph 15 of your brief, you say that the Associate Minister agreed to officials developing alternative wording in a meeting with the Secretary of Justice on the 31st of July. Is that correct?
Correct. It's correct.
And the Minister ultimately made decisions finalising the alternative wording on the 21st of August.
That was the date of our briefing, so it might have been a day or two after that, in which some short time after that, when the Minister made his final decisions.
My understanding from paragraph 31 is that it was signed on the 31st of August.
Oh, okay. Oh, no, correct. Must have been, sorry. Yes, no, you are right. It was signed on the 21st.
So the Ministry had 3 weeks to develop the alternative wording, consider the impact of the wording, and advise the Minister to the extent that they could in that time frame of the risks and consequences.
In terms of crystallising our advice, yes, but I'd note that we had done some preliminary thinking in the lead up to that period.
That preliminary thinking is reflected in the 12th March briefing. Is that right?
Go back. It's a long time in my world at the moment. I don't want to hold people up here, is that we had, I think in that initial engagements with the Associate Minister, we were exploring when the coalition agreement said based on the ACT Party policy, what scope we had to provide further advice on alternative wording or consideration. So in that context, we had sort of, as you would expect, gathered the relevant case law and other matters so that we were, had a good base of knowledge on which to work from and refresh our memories in that case. So that's what I mean by preliminary thinking, is that we didn't reach for the library shelves at that immediate moment. We had kind of considered all the thinking that's available to date.
Okay, and so that occurred early on. In the 9 August briefing, which is A31, page 16, paragraph 21, under next steps, it says here that officials need to explore potential wording. So you've done some initial thinking, but you hadn't really delved into wording or the consequences or risks of wording ultimately developed.
No, we hadn't kind of crystallised what ended up being in the advice on the 21st of August briefing.
So you hadn't finalised the wording by the 9th of August, so most of that work was done between the 9th of August and the 21st of August. Would that be correct assessment, perhaps sometime after the 9th?
Between those time periods, yeah, we would have produced drafts and had internal discussions to develop what ended up in that final briefing.
That's not a lot of time, is it?
Oh, no, it's not a lot of time. It's longer than sometimes and shorter than others.
I just want to move now to the RAS statement. The bill does not meet the RAS quality assurance criteria. And highlighted that the Associate Minister's directions limited the ability to conduct in-depth analysis to test the assumptions underpinning the problem definition and response, investigate and understand the unintended consequences, and undertake consultation with iwi and hapu experts and the broader public. That's at page 4 to 5 of the RAS, A29. You'd agree with that?
Yes, so that's a statement from the panel that assessed our statement that was made up of staff from the Ministry of Justice and the Ministry for Regulation.
No consultation with iwi and hapu experts or the broader public occurred before Cabinet's decision, did it?
No.
That was why the quality assurance criteria were not met. One of the reasons.
Well, that's one of the key considerations, because the quality assessment criteria highlights the value of undertaking engagement and consultation.
Given that the impact analysis was inadequate, but Cabinet decisions were nevertheless made on the 9th of September, a supplementary analysis assessment must be provided to Cabinet. Is that right?
It depends. I'd have to refresh my memory on the precise nature of all that bureaucratic requirement, I'm afraid.
Okay, that's based on the Cabinet Office Circular 22. I can't. No, I'm afraid I can't remember or sort of know off the top of my head what the precise requirements are now in the lead up to the introduction of the bill, whether we need to specifically do another assessment in this context. Okay. Do you think that you might be able to provide some answers around that following this hearing?
Yes, I can certainly go back to the requirements around regulatory impact statements and check those as against what we might need to do in this particular case.
Moving now to...
If you do so, can we get a copy, please?
Yes.
Thank you.
To the referendum, advice in the RAS statement notes that holding a referendum alongside a general election may risk public education campaigns on the referendum and the general election having to compete. How will the Crown ensure that the agency working education campaign engages with Māori on issues relating to the bill?
To be fair, we haven't given any deep consideration to how a referendum may be conducted. We're still in the process of working out the mechanics around that. Those references in the regulatory impact statement is based on our experience at the Ministry of Justice and what we did around in the lead up to the 2020 election. We did have 2 referendums on cannabis and end of life choice alongside the general election itself. And so we were just commenting there based on our experience of the need to make sure the campaigns are coordinated and well structured to be able to reach everybody. So we're sort of some way away from thinking or having done any detailed thinking about what we might need to do in developing any campaigns around this. And our other kind of context for that too is that there's the coalition agreements about having a 4-year term of Parliament also put to referendum. So we're just highlighting in that analysis for Cabinet that those are relevant considerations in designing that approach, but also that would have implications once you started looking at the budgets for for having sufficient resource to do that.
Has the Ministry of Justice received instructions on whether they will be involved in the preparation of materials for public?
No, not at this stage. We haven't got any decisions about what the next steps would be in that context.
Sorry, we didn't quite capture the question.
Has the Ministry of Justice received instructions on whether or not they will be involved in the preparation of materials for public education for a referendum?
Right, and the answer was no.
No, not at this stage.
Well over the 10 minutes.
Okay, I will leave that there then. Thank you, Mr. Chairman.
Thank you.
Thank you very much. We're going to take the luncheon adjournment until 1:30 p.m. Greetings again, everybody. We're about to start. We now have, on my list anyway, Tuko Law, 20 minutes, Kaupare Law, 10 minutes, and then Phoenix Law, 20 minutes. I am going to restrict you, Ms. Mason, to 20 minutes, if that's okay, so we can all ask our questions. 2 of our members have to leave at 3 o'clock. So
That's fine.
if you have to, you can put your questions in writing. We'll see how you go.
Thank you.
All right. So, Ms. Cherrington?
Yep. Apologies. Kia ora, Mr. Chana. I hope you had a nice lunch. My name is Ms. Cherrington, and I represent 2 claimant groups in this inquiry. They are Te Runanga o Ngāti Hine and Te Kapotai, both of whom are Hapu and Iwi and Te Taipukirau. So firstly, thank you for your evidence today. I have roughly 3 lines of questioning for you. They're mostly regarding further clarification. I'm sorry, Your Honour, I did come in late, slightly late, so if I understand that we're pressed for time, so I'll try and keep that short. Is that the understanding?
Yes, thanks. You've got 20 minutes, though. You've asked for 20 minutes.
Perfect. Sorry, I didn't catch the first part of that. Back to you, Mr. Chana. So the first question I have relates to the discussion of treaty principles in the Cabinet paper. If I can take you to the Cabinet paper, please, A27 at paragraph 10. And at paragraph 10 of the Cabinet paper, the Crown sets out what it views as the key treaty principles articulated by the courts and the tribunal. And the principles mentioned there are partnership, active protection, and redress. So my first question to you is, how were those principles chosen?
I don't know if I've got a sort of very erudite answer to that. They were just the 3 key principles that we highlighted based on the current thinking and jurisprudence and articulation of the principles, and looking at the Cabinet Office circulars around Te Treaty and Treaty of Waitangi guidance, and ones that were particular relevance to the exercise of considering these issues.
And I suppose you might have similar thinking then. How were the descriptions for those treaty principles chosen?
Again, they were drawn from, I think, existing materials and summarised down to what's in paragraph 10.
And I suppose the key concern for my clients is, why isn't Tino Rangatiratanga listed there when it's noted later on, I think at paragraph 45, as being a key reason that Māori have a significant interest in the treaty?
I don't really have a comment or view on that. We explore those issues further into the Cabinet paper.
But you would agree that Tino Rangatiratanga is a key principle of the treaty, in the treaty?
Yes, it was an important consideration in all of our advice.
Thank you. If I can take you next, please, to your evidence, and I'd like to refer you to paragraph 24.
Yes.
So at paragraph 24 of your evidence, it says the objective of the alternative wording was to retain the intent of the Act Party policy as per the Associate Minister's direction. Did the Associate Minister provide any other views or instructions on developing the alternative wording?
No, it was more in the context of we sought, as we had done throughout the process, about what scope was there for providing further advice to look at the wording of the principles.
And that scope is just what's in the materials provided. There's nothing outside of that.
No, those briefings were provided, and then, as noted in my evidence, we had some meetings with the minister that we sort of discussed that material.
And in those meetings, he didn't provide any clear instruction or direction as to the development of that wording?
No, there were broad discussions around our advice in the materials, but the underpinning was that it's the ACT Party policy that was being taken forward, and the intent of that needed to be retained was the overarching frame.
Thank you. And just as a bit of understanding for myself, has Minister Goldsmith had any oversight or input into these documents or into the development of the policy?
So Minister Goldsmith is the overarching portfolio minister, has been copied on the briefings that we provide because that's part of the standard approach with associate ministers. I'm not aware of what discussions may have occurred between Minister Goldsmith and Associate Minister Seymour in the context of ministerial consultation and what they may have discussed. I'm not privy to that.
But given your advice to the Associate Minister that this policy is not treaty compliant, did you raise those issues in particular with the Minister of Justice or the Attorney General or the Minister of Māori Development even?
So in terms of all of the advice that has been copied to Minister Goldsmith, and so yes, it has been raised with Minister Goldsmith. We have not, as Justice officials, discussed any of this with the Attorney General. That would have been something that would have been done as between ministers.
Thank you. If I can take you to paragraph 31.3 of your brief, please.
Well, just a question there, if I could. I just want to get clear. Did you discuss or circulate these documents to the Minister of Māori Development?
No, we did not provide the material that you've got in terms of our advice to the Associate Minister and Minister of Justice. We did not circulate those to the Minister of Māori Development. The Minister of Māori Development would have seen the draft cabinet paper.
All right.
As part of the ministerial consultation process.
And did the Minister of Justice, the Honourable Paul Goldsmith, receive a written explanation of the documents?
No, well, he received the documents directly.
Without
you'll see that most of them.
They were just CC'd.
No, well, we didn't provide. They were provided to him in his office, and we were available to discuss them with him should he wish.
Okay. And did you discuss it with him?
Personally, no, no more than to say that we've provided the materials and updates on process and how things were going. I didn't have any substantive discussions with Minister Goldsmith about these briefings.
Did anyone from Ministry of Justice?
I'm not aware of any substantive detailed discussion with of anyone from the Ministry of Justice with Minister Goldsmith, but I'd have to confer with colleagues to confirm that.
All right, thank you. Could you do that, please? Sorry.
Yes.
We go back to you.
Thank you. So, yes, following up that, Mr. Chan, if I can take you to 31.3 of your evidence.
Yes.
So it says there that the minister agreed to alternative wording of the principles as described in the briefing, but noted that this was subject to further refinement. Did the Associate Minister have any feedback at that stage in terms of what that further refinement was or what was required to be further refined?
Not in that. That was in response to that briefing on the 21st of August. He noted that he had agreed it, but with subject to further refinement. And in the days that came afterwards, in terms of finalising the draft cabinet paper for him, we got some further feedback and direction about what the principles should be for inclusion in the cabinet paper, and you can see on the record that there's a difference between, particularly in Principle 2, about what was advised in terms of alternative wording and to what was finally ended up in the cabinet paper.
Yes, because I did see that in regards to Principle 2, and it was a question that I had for you in terms of the removal. The first iteration said the Crown has a positive duty to protect the rights of hapu and iwi Māori. And then in the final paper, the reference to a positive duty was removed. Was there a reason from the minister for that? I mean,
no specific reason. That was the feedback we received in terms of his refinement of what we had advised.
How was that feedback received? How was that refinement received?
I understand it would have either been an email or a conversation from a member of his staff in his office.
But purely with the change to wording rather than explanation as to why?
Hang on. Yeah. From my recollection, I'm not aware of any reasons given by the minister or his office regarding those. They were just provided as feedback on what should the final cabinet paper look like.
Halfway, thank you. I'll move that into my next line of questioning, which relates to the language used in the advice to the minister. And I'll take you, for example, to the regulatory impact statement, which is at A29. Page 14.
Yep. Yes.
I want to start at paragraph 53. It says there's also a risk of damaging Māori Crown relations because the bill could be seen as an attempt to limit the obligations created by the treaty unilaterally. And in the next paragraph at 54, and I'm happy just to read this to you, you can follow along. It says, the lack of consultation is likely to leave Māori feeling alienated and excluded. And then the next paragraph from there at 55 says the bill could generate further division, posing a threat to social cohesion. So the wording used, words like could, might, likely, suggest that these risks or impacts are not as severe as they are for Māori. My question is, why wasn't stronger wording used, given the severity of the issues?
Well, I suppose looking at those paragraphs, we say, I suppose paragraph 53 is an example. It could be seen as an attempt, and then we go on in the next sentence to highlight what the tribunal concluded on that as evidence for that. So I'm not sure that we had any great, there's any real deep meaning behind the selection of words. We kind of articulated what the risk might be, and then either footnoted or articulated some of evidence or material to support that particular statement.
My thinking, though, is just because given the tribunal's findings on the severity of the issues for Māori, why was the language not definitive in saying the bill will create division, the bill will do these things?
I really don't have a reason to give you regarding that choice of language. We've, as I said, the drafting highlighted the risk and then provided the supporting material to explain why we thought that was the case.
Kapai, was that all you had to say? Sorry, I wasn't sure if you were continuing.
Yes, no, that's my answer.
All right. Can I take you then to paragraph to page 3 of the RIS A29, please?
Sure.
Yeah, perfect. I just want to take you to that first full paragraph where it says the status quo might also minimise the risk of damaging Māori Crown relations because the proposed bill could be seen as an attempt to limit the rights and obligations created by the treaty. And this would present a significant risk to the Māori Crown relationship and could have flow-on effects into other parts of the relationship. What are the flow-on effects that are being referred to there?
Oh, in that context, we're just saying you've got a particular risk in terms of the relationship in the context of this particular bill, and the flow on into other parts of the relationship is in terms of any other matters that the Crown and Māori would be engaging on or talking about.
Can you give us an example of what you think those might be?
Oh, in our particular case, we've been engaging with Iwi Chess Forum and other particular iwi on adoption law or criminal justice reform or any of the other things that we work on. Our kind of point that we're highlighting there is if we've got a damage to the relationship in this context for us, that would then manifest itself in a difficult relationship or make it difficult for us to have a good working relationship in other areas.
Which then could affect adoption reform and all those areas you just mentioned?
Yeah, as a general proposition, that would infect, I suppose, that relationship with the concerns that arise out of this particular area.
Thank you, Mr. Chana. I want to take you back to your brief of evidence. Sorry, I know I'm chopping and changing a lot. Paragraph 22, please.
Just a moment. Yep, paragraph 22.
And there you talk, you say the ministry contacted a small number of experts to see if they would engage on how to express the treaty principles in legislation, which you have spoken to today. My question is really around whether the minister provided any feedback on the responses from the constitutional experts and their discomfort in providing advice on only the wording of the bill when the underlying intent of the bill is, in their view, flawed.
No, because we highlighted that in that August 21 briefing, I think, where we sum it up in a set of paragraphs about what the challenges were in contacting people and summarised what their views were. I'm not aware of any particular specific feedback from the Associate Minister in regard to that advising of that.
Was there any instruction to try again or try other people in the list?
No, not at that stage.
Thanks. And I have a couple of questions in relation to the referendum.
A couple of questions is about, brings you to the end of your time, so that's great.
I'll be quick, I'll try. And just to preface, I know you've stated today that the referendum is still being developed, but I think I heard in your discussion earlier with Your Honour that the work for the referendum is intended to be done by November, but that the select committee will sit until mid-2025. If this is the case, what's the purpose of seeking to have the work done by November?
So that's a practical measure. So in order to have a referendum, we need to have the mechanical provisions to be able to instruct the Electoral Commission on what all the rules and operational requirements are. And so that normally needs to be passed in good time for them to be able to do whatever planning and operational work that they need to do. So in the context here, the commencement clause of the bill as introduced will say that it would commence on a positive result in a binding referendum, and then we'd need to have a place to enact those And as a matter of practicality, we're thinking it's probably easiest just to include those mechanical provisions in this particular bill so that they would be passed should the bill is passed and be available to then be operationalised. So it's more of a practical consideration rather than anything else at this stage to try and make sure the mechanical provisions that give life to a referendum, if that is what is enacted, are available and ready to go, and we're not sort of having problems about trying to do that after the fact.
Well, using your words that it's a practical consideration, is it practical for that work to be done by November, given the stakes?
Well, yes, because there's nothing. The key clause is the commencement clause, which says it will commence on the result of a referendum. From our point of view, most of those provisions are to be drawn from the Referendums Framework Act of 2019, which was since repealed, which was used for the conduct of the two referendums at the 2020 election. So from our point of view, there's only having a look at what modifications might be needed, but largely we'll draw from those existing provisions.
Thank you. Coming to the end of my questioning, but given the position of the constitutional experts and their view that the underlying policy of the bill is flawed, and the tribunal's findings in Ngā Mātā Pono, and the advice of Crown officials and yourself saying that the principles do not accord with the treaty, if the bill does proceed to a referendum, is there a concern that the education which surrounds the bill will then, and which is passed on to voters, will inevitably be misinformed, and that it's based on a bill which is not aligned to Te Tiriti?
There'd be a significant challenge in coming up with a public education campaign to properly inform voters about what the options and choices are. And we've highlighted a little bit of that in our regulatory impact statement about the need to have a properly formulated public education campaign.
And I suppose the concern from, the claimants'
I think that's
perspective
enough now, Ms. Charrington. You established the point, and it's well said.
All right, thank you. I'll leave it there. Thank you, Your Honour. Thank you,
Thank
Mr.
you, Ms.
Chana.
Charrington. All right, kaupare law, Aroha Hirawini.
Tēnā koe whakawā ko Ms. Peters tēnei, kaupare law. Tēnā koe, Mr. Chana. Nice to see you again. I'm Peter Peters from Kaupare Law and represent an applicant Te Hapu o Ngāti Rehia in this inquiry, as well as an interested party, Te Haupapa Kohatu Trust from Motiti Island in Tauranga Moana. Many of my parts I have already been explored with you by my friends, so you'll be pleased to hear that I have only a few questions remaining for you. Just following on from one of the partai from my friend, Ms. Charrington, you accepted that tino rangatiratanga is an important consideration in all of your advice, and yet it's not identified or specifically recognised as a principle in the cabinet paper. Assuming that you've read the Ngā Mātā Pono report, you'll be aware that the tribunal, in its interim report, found that the policies that are the subject matter of this inquiry are inconsistent with tino rangatiratanga as guaranteed in Article 2. You're aware of that?
Yes.
And in terms of the position that you've confirmed today, that the proposed principles do not align with the text or the established principles of Te Tiriti, and that was an answer to, I think, questions from my friend Ms. Sykes. In terms of the proposed principle 2, relating specifically to the rights of Hapu and Iwi Māori, would you accept that that wording or the principle espoused there still implies that Te Tino Rangatiratanga is subject to and derived from Kāwanatanga?
Well, yes, that's the advice we gave in paragraph 31 of our 21 August briefing, where we said the alternative wording would not accurately reflect Article 2, which affirms the continuing exercise of tino rangatiratanga implies that te tino rangatiratanga is subject to and derived from koanatanga and reduces Indigenous rights to a set of ordinary rights that could be exercised by any group of citizens. So we've kind of consisted that, and we've kind of made similar points in other parts of our advice.
So that finding then would still apply in the circumstances we find ourselves in at this point.
Do you mean in terms of what the
finding
the
from
principles?
Sorry,
in application to the principles as they're in the cabinet paper?
Yes.
Yeah, so yeah, no, that's, and we've provided that advice also on that 21 August briefing, is that the findings of the tribunal would also likely apply to the similar findings will be made likely in relation to the principles as currently drafted as well.
And in the evidence from some of the witnesses we heard from this morning, Ms. Coates and Dr. Harris had used the word amputation to describe the effect that this bill will have on Te Tiriti, on the Crown Māori relationship. Do you recall hearing that?
Yes.
And you may recall in the first hearing, one of the kai kōrero for one of my clients, Mr. Kepa Munro, he also espoused a similar kōrero in Māori to that effect as well, in terms of the direct effect that this proposed bill will have and is already having on Māori and hapu. Do you accept that that description is fair to draw in these circumstances?
Well, as a public official, I wouldn't use the word amputate or any of those types of things, and I can just draw you to, again, the advice that we've provided in this context, in which I've already said is that, yep, we do not, our advice is that it impinges on Te rangatiratanga, and it ends up in that position that rangatiratanga is derived from koanatanga, which is inconsistent with the articles and the principles of the treaty. So that's been our consistent advice throughout.
Tēnā koe, Mr. Chana. Those are my questions at this time. Tēnā koe te kaipakawa.
Mason?
Thank you. Tēnā koe, Mr. Chana. I'd like to start with the cabinet paper, and that's document A27, the Associate Minister's cabinet paper, and with paragraph 14, the Associate Minister says there that, in his view, the principles are a clear reflection of the intent of the text of the treaty. And I just wanted to ask you, when you gave advice to the minister that they weren't a reflection of the text of the treaty, what does he say?
Well, he doesn't agree.
He just says, I don't agree with you.
Well, that kind of sums it up, yeah.
Okay, all right. Has the minister been briefed about the Y1040 Paparahi o Taraki report, which looked in depth at the meaning and effect of the treaty?
Sorry, which report are you referring to?
So that's the Paparahi o Taraki, the Y1040, the Northland Waitangi report, which clearly set out the effect and meaning of the treaty. Has he been briefed on that?
We haven't provided a specific briefing on that particular report, but we would have, our advice draws on all of those sources. But no, we haven't provided a specific briefing on that particular report to him.
Okay. And has the Minister been provided with any advice on things that he can do if he disagrees with the courts and the tribunal's interpretations of the treaty? For instance, that it would be appropriate for him to request that those decisions be judicially reviewed?
No, we haven't provided advice of that sort.
Do you think that it would be wise to provide him advice as the Ministry of Justice that if he disagrees with some findings of the tribunal, for instance, that the appropriate thing to do would be to have those decisions judicially reviewed through the courts?
No, I mean, in this particular case, we're responding, I'd go back right to the beginning, is that there's a coalition agreement which we as officials and he as minister are being directed to implement, which is about this particular policy. And also in that context, as well as seeking a judicial review, it is open to the government to propose legislation to Parliament if they want to change the meaning of any particular findings of a court or disagree with kind of direction that the common law is taking. So we don't generally provide general advice of that sort. In this particular instance, we wouldn't have thought to have provided advice on taking a judicial review because there's a clearly stated policy and coalition agreement to be implemented.
Okay. So you would have heard the opinions and read the opinions of the expert witnesses, the three who were on this morning?
Yes.
And do you agree with them when they give evidence, when they say that there are barriers to Parliament sovereignty, that actually constitutionality requires that legislation be somewhat consistent with the treaty?
Well, they are the experts in the area and I am not. So I take their expertise on board, and there's a number of issues in there. And I think, as I commented earlier in giving evidence, this sounds like something that requires the deep consideration as part of the wider constitutional inquiry that's been established.
Okay. So would you then, if you haven't already, would you advise the Associate Minister that his bill, that the bill as it's formulated and the principles as they're formulated are actually contrary and don't align with the doctrine of parliamentary sovereignty?
Would I advise now that it's consistent with the parliamentary sovereignty?
Yes, based on the evidence this morning.
No, I'd advise him of. I expect after all of this, I would provide an update to the Associate Minister highlighting what has been discussed here today and the evidence and the expert evidence that's been presented. But I wouldn't go so far as to advise him that he is not capable of submitting this bill or introducing this bill to the House.
Would you accept that the legal status of the treaty is as an international document signed between sovereign nations?
Well, there's a number of findings of the tribunal and others that talk to that, and I would concur with the expert advice that's provided in that area.
Okay. So in that regard, can I ask why the ministry has not provided advice around what it would be appropriate to do in terms of international law, given that there's a difference in interpretation of the treaty?
So you're saying you were asking why our advice doesn't have any particular reference to interpretation at international law?
Yes, I mean, there are mechanisms available to the Crown if they have a dispute with Māori about the interpretation of the treaty. And I'm asking, why haven't these options been provided to ministers?
Well, I suppose that comes back to what we've summarised in our regulatory impact statement. There's a very clear commissioning from Minister and ultimately the Cabinet in relation to this particular policy, that we are here to advise on and assist in implementing the introduction of a treaty principles bill based on Act Party policy. So in that respect, as we lay out in the regulatory impact statements, we have been providing advice in that context, and the narrow options essentially of the status quo versus that particular option that's in the coalition agreement is what we've analysed and provided advice on. We didn't expand our horizons given the time constraints and the very clear directions that we've got from Cabinet.
Okay, but there is also an obligation to provide free and frank and neutral advice, which you have done. I think no one disputes that in terms of what the tribunal has said and in terms of consistency. But I did note that there's nothing at all on the international law options for government if it disputes the interpretation of the treaty. That would be
That's
correct.
right. We did not go down that path.
Okay, all right. And just to confirm, you agree, officials gave advice that principles 1 and 2 were not consistent with the treaty and the interpretations that the tribunal have come up with. That's correct?
Yes.
But you say that principle 3 is consistent with Article 3, is that correct?
How did we put it? I see. Oh, we didn't provide any extensive detailed advice in writing on that, but we went only so as far as they would have fidelity with the meaning of Article 3, but overall, in terms of the overall package, we were still of the view that the package of principles as being presented in the bill would create legal uncertainty and threats to social cohesion and institutional legitimacy, and concerns about the overall relationship between Māori and the Crown as treaty partners. So again, kind of in that broad context, we weren't saying that it's fine, but in terms of that particular narrow issue of trying to improve the drafting or the wording, we said that it did have some fidelity with Article 3.
Okay, all right. Now, I'd just like to turn to paragraph 22. And I'm still on the Cabinet paper.
Sure.
And that's the paragraph talking about when the principles would apply. And the Associate Minister ticks off as his preferred option the option that the treaty principles would apply with the interpretation of any act, regardless of, so not just acts where the treaty is explicitly referred to. Is that correct?
Mm-hmm. That is correct. He shows option 2 out of 3.
Right, okay. And then in the decision that's made at the end of the treaty paper, of that Cabinet paper, it says agree that the principles should assist with the interpretation of any enactment where treaty principles will normally be considered relevant. So he's just clarifying that agreement is that the treaty principles, the new ones, would apply to every act, regardless of whether it's got a treaty clause or not.
Yes.
Okay, all right. Now, the second principle that Associate Minister Seymour wants, essentially, and I'm just trying to understand this, can you please confirm, does it say, or does it mean that the treaty will only be relevant where it's specified in legislation or treaty settlements?
Sorry, I didn't catch the first part of the question. It sort of skipped.
Okay. Right. So principle 2, it talks about hapu and iwi rights, and they differ only where it's specified in legislation. So am I right in saying that it's saying that treaty rights are only available where specified in legislation?
In essence, yes, where they differ from those rights enjoyed by everybody, they would only be there would be only those that are actually laid out in legislation as the essence of that principle, because then it goes specified in legislation or in treaty settlements, which in essence is also in legislation or other agreement with the Crown.
Do you think there's some kind of logical problem where there's a principle that says that the treaty rights are only available where they're specified in legislation, but the application of the principles is everywhere, is in any enactment? Do you see some problem with that, the coherence with that?
Could you explain what you see as the problem there?
Well, there's a principle that says treaty rights are only available where they're mentioned in a statute, correct?
Yes.
Okay, and then there's a cabinet paper that says the principles will apply to every enactment where relevant, not just not just the ones where it's specified.
No, well, how to explain it? So that's the principle, and then when you go to interpret any enactment where it may be relevant that you consider treaty principles, you're to use these principles, not any of the other principles that have been developed over the last 40 years, is the sort of simple explanation.
But they only apply where there's an enactment that refers to them, is the second principle.
No, that's not the principles. It's talking about what rights you might enjoy are only those that are specified in legislation. That is the principle. And so that would be the principle that you would apply in interpreting any other piece of legislation.
Okay, all right. Now, sticking with the second principle, it talks about hapu and iwi, and of course the treaty talks about everybody, including whānau, and also in recent contemporary times, the tribunal has said that treaty rights also apply to urban Māori authorities like the Waipirira Trust. Can I just ask why it was narrowed down to only hapu and iwi?
So from recollection, I think because that was drawing on we have, sorry, I just need to refresh my memory of the different briefings that have been going backwards and forwards. No, I think we were just drawing at the high level. Hapu and iwi is that in our discussions with the minister and focusing the discussion there.
But would you agree that it cuts out? Would you agree then that iteration of the principles cuts out a vast group of Māori who otherwise would be entitled to protection under the treaty?
Well, I haven't actually given any detailed consideration to that. We had focused on hapu and iwi in that particular set of advice, and that's what we've talked about there.
Okay, and you're just reiterating, you might or might not be aware, but I think it's Y313 is the tribunal report. It's the Waipirira Trust one, and it says that urban groups are entitled to choose their representatives, especially when they've been alienated from their iwi and hapu, and those representatives like the Waipara Trust are a treaty partner. Are you aware of that report?
Yes, I'm aware of that particular report.
So those people would miss out, wouldn't they, on treaty protection?
Well, a number of people and groups would miss out on treaty protections based on the articulation of this particular principle.
Okay, all right.
And that's our advice. Yeah.
Okay, I just have one more question, and that's in relation to the referendum. And in the RIS, you talk about the public information program. Which agency, and I know you haven't developed the policy yet, which agency would be responsible for the public education, for putting the materials together?
I do not know. We haven't kind of considered who might be appropriate to do that yet.
Would it be someone under Associate Minister Seymour's direction?
I don't know. I can't give you an answer yet because we haven't actually given any thought or consideration to what a public education campaign might look like, or who would conduct it, or how it be managed.
Would you agree that it would be inconsistent with the treaty and unfair if an interpretation of the treaty was given which was not based on what the tribunal and the courts have said about the treaty?
So in the context of the public education campaign, or?
Yes, in the context of the public education campaign, because of course it's very important what they say.
Oh, well, what I can say is that the public education campaigns for cannabis and the end-of-life choice referendums at the last election, there was very much a focus on not being advocacy campaigns, but very much explaining the background, history, and the implications of the different proposals that were in those. And so similarly, even with the flag referendum, you had there about sort of explanations of the design and whatever the implications were around all of that. So public education campaigns, and for these contexts that are delivered by the government, are very much in kind of politically, have always been traditionally politically neutral in explaining, so people can make their choice based on being fully informed. So would expect the same approach to apply in any referendum in this context.
Okay, I just have one final question. Would there be a cap on the amount of campaign spending that would be allowed by relevant groups?
Yes, that's part of the mechanical provision. So if you have a look at the referendum frameworks legislation, I think that would have had some that had provisions that look at promotion and third-party promoting and things like that. I can't quite remember exact details, but there is references to transparency and funding that needs to be respected in that respect.
Okay, sorry, I just had one final question. Do you think that the very fact of holding a referendum on a matter related to the interpretation of the treaty is in itself a breach of the treaty?
Yeah, well, our advice is that, where are we? Well, I think we reflect what the tribunals found, where I think having a conversation about the treaty is important, but a tribunal on this referendum and the bill is not the ideal way of doing that. And we've also got in our advice how a referendum is probably not the appropriate way of approaching this type of issue, because you've got a potential majority imposing its will on a minority, and it's also the nature of the issue as between agreement between the Crown and Māori. It doesn't lend itself to this type of referendum approach.
Okay. Thank you very much, Mr. Tuna. Those are all of my questions. Thank you.
Thank you. I'm going to ask Ms. Kapua to ask her questions. The Mr. Prime will follow her. And if they have to leave before we have finished, you may see them getting up and leaving, but they will read the transcript following today and make sure they're familiar with what happened after they left. Right, Ms. Kapua?
Thank you, Your Honour. Thank you, Mr. Chana. I just had a couple of questions, and you've been very clear about the position of officials and the advice that's been given to the Minister. And I think in your words that he hasn't taken that on board. There's been some discussion in the media about the Minister's criticism of official advice. I think there's references in the Cabinet paper to him disagreeing with the advice, and that he's disappointed with some of the advice and so on. Bearing that in mind, your expectation was that this will go to the Justice Select Committee, and the Justice officials will be the ones that will be doing the paper to the Select Committee, or giving the advice to the Select Committee. That's correct, isn't it? So,
yes.
Given that position, would you anticipate that the advice that you have given to date, and that's contained in the Cabinet papers and the regulatory impact statements and so on, would you consider that your advice to the Select Committee as a whole is likely to change?
No.
In terms of the introduction of the bill into the House, is it likely that the Ministry of Justice officials will be the ones that will be drafting the speeches for the Associate Minister for the introduction of the bill?
Yeah, we generally provide materials to support the Minister and the House, and that includes draft speeches, but there are only that drafts that ultimately it's the Minister who will finalise what he wants to say to the Parliament.
So if he disagrees with the information contained from the officials, he will be adding his own version. And
the speech is his speech, and he will draft it according to his wishes.
Given that position, is it slightly untenable for the Ministry of Justice officials to be, or the Justice Select Committee to be hearing any submissions on this bill?
Oh, sorry. There's a little cutout again there.
Oh, sorry. Is it slightly untenable, given the advice that the Ministry of Justice officials have given to date, given the position of the Associate Minister in relation to that advice, is it slightly untenable for this matter to go to be referred to the Justice Select Committee?
No, I wouldn't suggest wouldn't think any of that has any difficulty in going to the Justice Select Committee. We could go to any Select Committee, as I've said, but the normal practices that are built from a justice portfolio goes to the Justice Select Committee.
Does the Minister have the right to nominate the Select Committee that he wishes the bill to go to?
Just digging into my memory of standing orders, there would be a motion that the Minister puts to the House, which would just be to say which committee it's referred to and how long. So yes, it would be the Minister that identifies which committee, but in technical terms, it's the House that passes that motion and to which of its committees it would go to.
Right. And so there's been no discussion about it going to other than the Justice Select Committee?
No, we haven't had any discussions regarding the committee.
Okay. It doesn't matter. Yeah. But it could go to another. And this is sort of not referring specifically to anything in your brief, but were you part of the advice from the Ministry of Justice on the proposal to disestablish Te Arawhiti?
No.
Are you aware of the proposal by the Ministry of Justice, officials or some officials, to that originally was to disestablish Te Arawhiti?
So this is in terms of the current proposals, you mean regarding taking some functions from Te Arawhiti and transferring those to Punikokiri because of the, and that's being led by the Minister of Māori Development in part. And then you would have the remaining functions in Te Arawhiti, and my understanding there was some discussion about what form that remaining function should take. Would that just be a stripped down Te Arawhiti? Would you incorporate that into the Ministry of Justice, or other options that might be available in terms of organisational form? So that's my understanding of what was being considered and then decided upon.
So the report that the Secretary for Justice had put forward the proposal to disestablish Te Arawhiti and to subsume what remaining role it had into the Ministry of Justice. You're not aware of that?
Not specifically, but I'm aware there were a number of options. Once you took some of the functions out of Te Arawhiti and transferred them to Punikokiri, there was a question about what would you do with the remaining functions? Right. And so one option would be to subsume them into the Ministry of Justice, because that was the form it took way back when it was the Office of Treaty Settlements, when it was a business unit of the Ministry of Justice.
Right. But that would mean there would be no Te Arawhiti. If you disestablish Te Arawhiti, there would be no Te Arawhiti. It would be merely a unit or a part of the Ministry of Justice. Is that correct?
Yes. Well, yeah, that would be that was one of the options, as I understand it, considered, which was based on in the past experience of how it was established.
Right. And as it has been reported, the Minister for Māori Development didn't agree with that option, and so Te Arawhiti lives on with limited functions, and the rest have gone to Te Punikokiri, as you talked about at the beginning. Is that correct?
Yes, my understanding is that work is underway to effect that change.
Okay. The Cabinet Manual from 2023, are you aware of whether that's been altered or amended in recent times?
No, I'm not aware of any updates or changes to that version.
Are you aware of what the obligations of a minister introducing a bill like this has in respect of the Cabinet Manual?
Yes, the teams, we rely on that in terms of crafting the Cabinet papers.
And given the implications in relation to Te Tiriti o Waitangi, would you say that the process by which this bill has been presented is in accordance with the Cabinet Manual?
If you look at the regulatory impact statement, that highlights where some of the deficiencies are in terms of the breadth of options and the amount of considerations. But that is, again, inherent part of the process, and that's the transparency that comes with regulatory impact statements. As part of that is to highlight where those deficiencies are. So in one respect, in terms of substance, there have been some issues, but in terms of presenting a paper to Cabinet, I think at a process level, you could say it complies, given that all of that material has been presented to Cabinet as part of its decision-making processes.
Thank you. Are you familiar with the government response to the Fourth Universal Periodic Review?
At a high level, yes.
Okay. Are you able to enlighten us as to why of the 259 recommendations, all of the recommendations related to the Treaty of Waitangi were noted, which actually essentially means they're not supported, and why those recommendations were merely noted. Was there a discussion at a high level? Was there some reason why, in reporting back, every recommendation from the United Nations about the Treaty of Waitangi was merely noted?
No, I'm not in a position to answer that.
Were any of those matters rejected or noted, matters concerning this bill?
I'd have to go back and check the recommendations that were made.
Could you do that in file following this hearing? Thanks.
Yes.
Just a final question, which is really something I guess that Dr. Harris responded to, and it's the issue about the process by which these three principles that are stated in the Cabinet paper stated to be principles yet mirror articles, and I think in relation to the advice that's been given by you and by the ministry, whether you or anybody who has been working on this considers that there is a difference in relation to using the term principles for this bill and the current proposed outcome, which is a reflection of the articles. Has there been any assessment within the ministry of how that sits in relation to Te Tiriti o Waitangi?
If I understand the question, the starting point was the ACT Party policy, and they had described three principles which they said was derived from the three articles, and we've essentially been working within that framing in terms of adopting or proposing and refining three principles which capture and are derived from the three articles. So I haven't given any much thought in terms of those framings. Beyond that, is that's the frame that we've been working within.
So given that position, and given the history, I guess, of the jurisprudence around principles that you've referred to in your advice, would you accept that the what is being proposed to carry out the ACT policy is a long way from providing certainty or clarity in relation to the principles of the Treaty of Waitangi?
Well, I think we kind of traversed that in a number of our pieces of advice about if these principles are to be enacted and go onto the statute book, then they would be subject to interpretation and application by courts and tribunals to the facts that come before them, and that would be a departure from the jurisprudence that's developed from the last 40 years. So that would then result in a period of uncertainty and change as those principles as articulated in statute are applied.
So the objectives, and I'm not quite sure, because there appears to be one objective which is as soon as practicable, but the three reasons in the Cabinet paper are about a national conversation, and we've traversed that, and clarity and certainty. So you wouldn't agree that it's the position of the officials that none of those three reasons for this bill are met by what is proposed. That
if those are the
sums up
purposes, we think. Yeah, we on each of those we've said that we don't think it would go about it creating a national conversation, and we don't think it would create for a period of time some uncertainty because you're disrupting the existing jurisprudence. National conversation wouldn't be. This approach is not conducive to a wide national conversation. No, so that's been our advice. That's summed up in, I think, the regulatory impact statement is probably the place where we sum that up across all of our bits of advice.
Thank you. And as has been stated today, one of the objectives to pass this bill as soon as is practicable.
Mm-hmm.
And is that
to introduce the bill to the House as soon as practicable.
And is that an objective of the Minister or an objective of the Crown?
Well, that's the from that is what is stated in the coalition agreement. Introduce a treaty principles bill based on the existing Act policy and supported to a select committee as soon as practicable. So that is what's in the coalition agreement between the Act and national parties, and then has been agreed by Cabinet as the basis of government, and that Cabinet Office circular that we've been referring to says that we are to go about as officials and ministers to implement that. So from that point of view, it is a Cabinet mandated requirement, I would say, to introduce and support to select committee as soon as practicable a bill of this type.
So it's a Crown objective?
Yes, because it's being endorsed by Cabinet.
Okay. Thank you, Mr. Chana.
Mr. Prime?
Yes, thank you. Just two short questions. Good afternoon, Mr. Chana. Given the two of the three coalition partners have already indicated that they would not support this bill past the first reading, does your department then tend to drag the chain a bit, or do you still go all out as if this legislation is going ahead?
No, we don't have the luxury of not doing our job, which is to prepare a bill which is capable of being enacted. So in terms of all of the requirements of the Cabinet Manual, the quality assurance requirements that Parliamentary Council have, the bill needs to be, if it should be enacted, it does need to be workable and give legal effect to the policy that underpins it. So from that point of view, we don't do a slapdash job or cut corners. We still need to be able to introduce a bill that meets all those standards for a government bill to be introduced.
Good, thank you for that. And just following on, given that indication from, well, the majority of the House, does your official advice extend to giving financial advice, like the futility of something that may not go ahead?
Not kind of in such pointed terms, but as I was sort of talking in previous answer to previous questions, we have a particular capacity to deliver policy advice on law reform, and we would talk to ministers about how they'd like to deploy that. And so within that context, we would have the discussion about saying, where did you want to put our efforts? And then within that, there's the many trade-offs that come, as I think I've mentioned at the last hearing. We've got at least 40 different bills on our program of work for this parliamentary term, and it's a trade-off question about where would you like to put our effort. So we would address it in the round in the context of discussing our work program with ministers.
Thank you very much. Much appreciated.
You could both leave if you have to. Just when you're ready, you can leave. All right, Dr. Suter.
Tēnā koe, Mr. Chana. Well, first of all, the ACT Party policy, the original one that regarding the treaty principles, had phrases in te reo Māori taken from Te Tiriti, There's been no mention of the fact that there's no Māori language anymore in these new principles. Is that based on, how did that come about? Is that based on advice from you?
We didn't provide any specific advice, but our advice has been presented in English, and we've been focused on trying to determine an articulation with the minister. I get an understanding from the minister about how he'd like to articulate those, and that's been the conversation we've had about trying to look for alternative wording which enables us to reflect some of the existing jurisprudence.
Yeah, because there was quite some consternation from the Te Reo Māori experts at the last hearing, and I wondered if that influenced the change.
Well, for us, it did bring into sharp focus that there was a whole lot of difficulties, as the experts had raised, about the te reo that had been used in the description of those. And so while we didn't do anything explicit, we've been focused really on trying to articulate it in English as clearly as possible.
Okay, thank you. So have I understood this right? In terms of the treaty experts that were going to be consulted but weren't consulted, does that mean that the PCO, the people who are drafting the bill, now have no access to any external treaty experts?
Yes, they are doing their work, and they are providing us with drafts, and we're providing them with feedback along with other agencies like Te Arawhiti and Te Punikokiri, but no, there's no external experts engaged in the process.
Yeah, I had been wondering why there was such a rush to get this bill out there, but I understand now it's it goes back to the coalition agreement, and that as soon as practicable now means November.
That is what the coalition partners have decided, yes.
Right. In reference to para 35(8) in your evidence,
yes.
35(8). I find this perplexing, especially since the bill is not expected to pass the first reading. So I'm unclear about what this could actually signify. Can you explain?
Are you referring to that they've agreed that in accordance with agreed coalition process, the coalition partners will be free to differentiate publicly?
Yes, yes. What does that mean?
Well, it means that they can take, normally you have Cabinet collective responsibility about anything that's decided in Cabinet, and then if you look at the Cabinet manual, there's the agree to disagree chapters, which kind of what you need to be able to have a coalition to run successfully, and then if you refer to the coalition agreements themselves, they reflect that sort of language about being able to disagree. So from my understanding of this, it's just formally recording that those agree to disagree approaches have been engaged in this case, and that leaves the three parties free to speak from their own perspectives and not be bound by what's Cabinet's decided in this particular minute about this bill, because normally once a bill has been approved by Cabinet, all of the ministers would be then bound by collective responsibility to it and not speak against it.
Okay, yeah, I understand. The other questions have been asked, so thank you very much for your evidence.
Thank you.
Professor Williams.
Good afternoon, Mr. Chana. Thank you for giving us the time. I just got one question and one query. The question relates to the Cabinet decision at 35.7, which is the 6 months period of the Select Committee through to the 16th of May 2025. And there's quite a lot of evidence that you've given and others have given about various aspects of the decisions. that have been made by Cabinet, but I haven't seen anything in your evidence about the choice of 6 months before the bill will be reported back, and if the other two parties to the coalition continue to take the position they've got at the moment, it'll then be at an end. So did you or anyone else amongst the officials, or are you aware of any documents from officials about the length as to whether it might be a shorter period before this bill comes to its end, if the National and New Zealand First parties stick to their current positions?
No, we didn't. We haven't really provided any advice on the length of Select Committee. Why 6 months? That's the default. Understanding orders, your default period of referral to a Select Committee is 6 months, and then decisions are made whether it should be shorter or not. And understanding orders, if it's going to be less than 4 months, then you have to have a specific debate and motion in the House to set a period of that length. So that's in the context of standing orders. So we were really just going with the default of 6 months unless there was any other consideration. And given the purpose in the ACT Party policy was to have open it up for submissions, and in their purpose there was to have that conversation about it, that was why the default 6 months was allowed for, to enable that to occur.
Thank you. The reference to the standing orders makes that much more clear to me. Just one other little query, that Tuko Law provided a chronology on the Treaty Principles Bill, which is 3.3.37A, which I found helpful, and they've got a change of colours from 22 July onwards as to issues. Have you seen that document? And really, my question is
to be reminded of it.
Well, I don't have a question about it. If you have a look at that document and you find there's anything in there that you think is incorrect about the chronology from the 22nd of July onwards, I'd be obliged if any corrections could be drawn to our attention.
Oh, yes, absolutely. We can have a double check on that based on our timeframes.
Thank you.
Derek Fox.
I've got one question, Judge, to Mr. Chana. First of all, thank you, Mr. Chana, for your evidence with a very interesting reading, in and outside of the lines. As an official with the Ministry of Justice, you will have noticed, probably as most of us have, that in the period that this government's been in office, there has been what some people in the media have described as an assault on Māori one way or the other, whether it be on Māori wards, on the foreshore and seabed, on the principles of the Treaty of Waitangi, and on adoptions and so on. As a Ministry of Justice, do you see this as being something unusual, untoward, and maybe grossly unfair?
I suppose, commenting from my role in the Ministry of Justice and of the items that you have raised in terms of the policy proposals that have been taken forward about Māori wards or Section AA of the Oranga Tamariki Act, as a Ministry of Justice, we have a particular role in being consulted on matters of constitutional import or things that affect the Human Rights Act or the Bill of Rights Act. And in each of those areas, we have provided comment and advice, which is based on and similar to the advice that you see presented in the context of this inquiry. So those are the parameters of this government are set out in their coalition agreements, and they have adopted that as their way of operating, and that is the philosophy or approach that they're bringing to issues. We continue to provide free and frank advice in the context of the policy approaches they want to take, which, is reflected in here. So I don't think I'm in a position to provide an overall commentary regarding the fairness or otherwise of the government, but I can say that there are issues that of particular constitutional and human rights issues that have been raised throughout those, and we have been providing our advice into those processes.
In terms of the experts and expertise that it was suggested that you should find to discuss these matters with you, were you surprised that in the end you found one person, but that people weren't prepared to get involved in that discussion with you?
No, once we shared the list of people that we had internally been thinking in the context of the earlier hearing, I did receive messages from people saying they did not want to be involved. And then throughout the process, and particularly once the tribunal's interim report was released, there very much was people did not really want to be involved. And also sort of one of the key issues was the fact that we were only consulting on the expression of the policy in draft legislation rather than engaging and consulting on the policy itself. So that for people meant that they did not think that would be a valuable use of their time in that process. So ultimately, I wasn't surprised that that's where we ended up.
Okay, thank you very much. No further questions, Judge.
Thank you, Mr. Fox. Dr. Phillipson?
Thank you, Judge. Tēnā koe, Mr. Chana. Thank you for this and for all the very helpful documents that you've filed. I have a few questions. I wondered, at what point was the decision made that an alternative wording for the principles would need to be developed?
It wasn't so much need to be developed. I think from our earliest engagements with the Associate Minister, we were asking whether there was a prospect of being able to consider alternative wording to what was in the ACT Party policy. So if I refer to the our timeline and my brief of evidence, I think that would sort of crystallise going into the end of July. And that was the meeting between the Secretary for Justice and the Associate Minister on the 31st of July, where we got the official go-ahead to present some alternative wording to the Associate Minister to consider.
So that was before the tribunal. Thank you. Some of my questions, for example, about the exposure draft have already been asked, so I won't go there. So in your brief of evidence, you said that the Associate Minister decided or selected alternative A for the Principle 2. Do you know the final wording of that in the Cabinet paper is quite different? So am I right? I think you already answered this, but I just want to confirm it was the Minister, the Associate Minister, who decided upon the wording that went into the Cabinet paper?
That's right. He did in somewhere. Yeah, so if we kind of set that out in paragraph 31 of my brief, which is that the Minister did agree to option A, but had noted that it was subject to further refinement, and then he provided by his office further refinement, as it were, which was the language that ended up in the Cabinet paper.
Right, okay, so it was from his office, not directly from him. Thank you. You said that the time for the Parliamentary Council's office to draft the bill was truncated, and that would affect what kinds of issues they would consider. I don't know much about how they do their job, so what kinds of issues do they normally consider when drafting a bill?
Their challenge is to reduce to statutory form what sort of the general statements that are in Cabinet papers, and we try to assist them in providing drafting instructions, which kind of tries to draw that out. In terms of what they need to do then is one, it is about trying to come up with language that faithfully implements the policy intentions. But then further beyond that, there's what transitional provisions you might need in terms of other enactments that are affected, what consequential amendments you might need to have to align it up with other pieces of legislation. In this context, we've noted that in how you approach treaty settlement legislation, do you need a savings provision, or what other mechanisms would you have to achieve that policy objective of not affecting existing treaty settlement? So for them, it's how do you kind of give effect to that with quite specific language. And so truncating that time obviously just reduces the amount of time that they have to give deep thought to it. And then the usual practice is that they would send drafts to us with queries in it for clarification, and there'd be an iterative process backwards and forwards, and the number of iterations would be limited in a limited amount of time.
I see. And are you expecting that as part of that process, the wording of the actual principles as they're expressed in the cabinet paper, is it possible that they might change? Or is that
Yes, that is always the case. So that whatever we might, as policy officials and ministers, have in cabinet papers, they would be subject to the expertise of Parliamentary Council in turning that into draft legislation.
I see. I'm not sure there's much room to change them, though. They're very specific.
I will wait to see what Parliamentary Council what magic that they weave. That's all I can say.
Thank you. So do you know, has the Prime Minister stated as Prime Minister that the bill will not be supported past Select Committee, or has he only done that as the leader of the National Party? And is there a significant difference between the two?
As a matter of fact, I can't probably give you a definitive answer about which hat he's been wearing on when he's been making particular statements, but I suppose the best thing I can do then is refer to the Cabinet Minute, which we were talking about previously, where we have the agree to disagree recommendation, as it were, about each of the parties being able to express their views. So in that particular context, the starting point, I would say, is that those sentiments are probably expressed more as leaders of their particular parties rather than as their ministerial roles.
Right. So in the cabinet paper, they've agreed to express different views. As party leaders, yes. He has said, and says, Mr. Peters, that they won't support it past the committee. So there is a distinction. Yeah, and that would be a matter that for them to then express in the appropriate parliamentary setting. Yes, thank you.
Can I just have you confirm something just based on that, Dr. Phillipson? I hope you don't mind. Can I just follow? So the comments made by the Minister, the Prime Minister, and the Honourable Winston Peters have been made, you say, in the context of them being leaders of their various parties, which the Cabinet Circular permits. Is that what I heard you just say?
That's my understanding of how they've been expressing that in the context of what they agreed in the coalition as party leaders.
That's right.
So their commitment is the two parties has been to only support it to Select Committee.
That's right. Well, no, their commitment has been to support it to first reading in the past. As a government, they've agreed through their Cabinet Minute to a process which goes to Select Committee. And a Select Committee process that goes on for 6 months. So it could be the case that as a government, they could change their mind and enact this legislation.
So the commitment that I've noted here is that it's to support it to a Select Committee, and so that's.
Well, go back to the coalition agreement. What did the coalition agreement say?
Said introduce a treaty principles bill based on existing Act policy and support it to a Select Committee as soon as practicable.
So it was in the coalition agreement?
Yes, to support it to a Select Committee.
All right. Sorry, Dr. Phillipson.
No, that's fine. Thank you, Judge. So in terms of the reworded principles that you put forward in your briefing and that were then altered by the Associate Minister, the point is made though in the documents that you understand those redrafted principles to still be based on the Act policy, don't you? Is that correct?
So our advice was provided in the context of still implementing the Act policy. It wasn't to kind of de novo come up with a clean set of principles.
No. Okay. Thank you. And just for my own understanding, because I hadn't appreciated this issue until it's been raised today, do you consider that the statements made are actually state principles? Because we've talked about what's been talked about in here, how actually they are statements of what is understood the articles say. Is that principles?
I haven't given it any great deep consideration in the context of all the other stuff we've been advising on. Well, they wanted principles, and we've expressed 3 statements, and they've been described as principles. Is probably all I've got to say.
Right. Okay. Thank you. You didn't mention in the, forgive me if I missed it, I don't think you mentioned the UN Declaration on the Rights of Indigenous Peoples in the regulatory impact statement.
We've mentioned it somewhere. I'm not sure. Where did we mention those things? It's in the cabinet paper.
Yes, it's in the cabinet.
Because the Associate Minister agrees with us in that expression. In the regulatory impact statement, where did we put that up there? Oh, I can't remember off the top of my head whether we refer to it again in the regulatory impact statement, but I can always double check that and highlight the passage if we have referred to it there, but I suppose I just highlight again the cabinet paper and the regulatory impact statement presented to cabinet as a package, and so we had it was at least highlighted in the cabinet paper itself in terms of the specific reference there.
We shouldn't take anything from if it's not mentioned in there.
No, as I say, the regulatory impact statement and the cabinet paper are presented together as a package for the cabinet consideration of the issue.
And my final question, in the cabinet paper, the Associate Minister rejected your advice on the basis that you were giving advice on the principles as they are, whereas the whole intent of the bill is to change the principles. And I just wondered, I'm not sure in your role as an official if you can express an opinion on that, but if you can, how do you think that reasoning stacks up in terms of assuming that the bill will pass and therefore the principles will become what's in the bill, or whether your advice should in fact legitimately be on the principles as they are now? I was confused by that statement in the cabinet paper, and I wondered if you can help me with that.
To the extent that I can help, I mean, our advice starts necessarily from the law as it is now and the jurisprudence that exists now and the principles that are here now, and Cabinet circulars and decisions past have kind of guided the approach. The Cabinet Manual, the Legislation Design and Advisory Committee, the Regulatory Impact Statement approach all kind of sets out the approach to treaty issues and constitutional issues. So our advice necessarily starts from that point of view about what it is now, and then our advice is then applied to what it is that the Minister is proposing to change it to. And we've, as you've seen in the materials, sort of worked our way through that in terms of what does the change mean, what is the departure from what we have now to what's been proposed. So to that extent, I can say that the Minister has received and considered our advice, and so as officials sometimes there's not much more you can really ask, that the Minister has considered and taken on board your advice, and ministers are free to not agree with our advice.
Yes, yes. But your selected option, your preferred option was the status quo.
Yeah, as we laid out in the Regulatory Impact Statement, if you're choosing between what's been proposed and the status quo, while the status quo has deficiencies, our advice was to go with the status quo because that preserved what we have now and provides a basis to continue to develop that or have a conversation about it.
Yes. Thank you, Mr. Chalmer. That's all my questions. Thank you, Judge.
Thank you, Dr. Phillipson. Right. Just to follow up from Dr. Monty Suter's question regarding Te Reo Māori, do the drafting instructions contain any direction to translate text of the bill or any part of it into Te Reo Māori?
No, we don't have any instructions about Te Reo Māori.
So it'll be totally in English, the bill?
At this stage, yes, I might need to come back and clarify that, but at this stage, my understanding is that we're promoting just having a bill that's drafted in English.
Right. And at paragraph 49, you deal with the drafting instructions having gone to Peace Parliamentary Council's office, and you mentioned the Legislation Act. What provision of the Act are you relying on? Do you know offhand, or could you get back to me about that?
I can get back to you on that. Is it? No, I'll get back to you.
So have the drafting instructions already gone to Parliamentary Council's office?
Yes, they have.
All right, thank you. Now, at paragraph 38, you set out the principles or statements.
Yes.
Perhaps even declarations. Anyway, civil government, the first one. Was it your advice that led to this wording?
Yes, so there our briefing that set out the alternative wording that we put to the Minister, and I think in this one he adopted the language that we had proposed.
Okay. So the Constitution Act 1986 expresses this clearly already. So
yes.
what benefit, what does it add to existing law?
Well, in part, our proposal to use the same language is to ensure consistency with what is already currently in the law.
So that was the point, to achieve consistency with the Constitution Act 1986?
In part, yes, so that it reflected what is already there in the law.
To what extent is this a reflection of, I think you responded to one of the questions you were asked from Ms. Kapua, that it was an attempt, these principles, at least when you were in drafting, or your team were drafting, there was an attempt to derive these statements from the text of the treaty. Is that what you said?
No, it wasn't so much derived from the text of the treaty. It was that overarching frame was still that we are still implementing the Act Party policy, but in terms of providing some alternative wording or considering different ways of expressing that policy intent, we're looking at ways to incorporate some of the existing principles or jurisprudence and have that reflected in the statements.
All right. In terms of the second matter, and I've called up on my phone the Māori Community Development Act, Section 18, which sets out the general functions of the New Zealand Māori Council in respect of all Māoris, shall be, amongst other things, at 1.4, to apply and maintain the maximum possible efficiency and responsibility in their local self-government and undertakings. So it reads like this: the general functions of the New Zealand Māori Council in respect of all Māori shall be to consider and discuss such matters as appear relevant to the social and economic advancement of the Māori race, to consider as far as possible, etc., and then to promote, encourage and assist Māori to preserve, to apply and maintain the maximum possible efficiency and responsibility in their local self-government and undertakings. That's in the legislation. So how do you think this declaration or statement will impact the rights of the New Zealand Māori Council to undertake its statutory functions under Section 18?
I haven't given consideration to how
will you have a look at it and give us your opinion on it?
We can.
Thank you. I raise it because it's an example of how this legislation might in an unintended way, impact on other issues besides those that the Minister is seeking to address. In terms of the right to equality, you heard Dr. Phillipson ask earlier this morning about the fact that the text of the treaty deals with more than the right to equality. So obviously this is a statement that is designed to minimise Māori rights under Article 3 and the current treaty jurisprudence known regarding the treaty principles. Would you agree?
In terms of this particular articulation, I suppose overall, as we've said, it does limit Māori rights and interests. And in this one, yes, there would be elements of that as well in terms of how it might be applied, given what's enjoyed at the moment.
So then do you want to think about the advice that was given, that equality before the law and the policy approvals for progressing a Treaty Principles Bill A27, paragraph 21, whether or not you would agree that that doesn't, the approach that you can't say that that statement or that declaration, what you describe as a principle, is in fact a principle that has the most fidelity to the meaning of Article 3?
No, I think we were simply saying it has some fidelity in that it does recognise some rights and interests. But again, as I said at the outset, overall, we were providing advice in the context of implementing the ACT Party policy.
Right, but it's recognising the rights and interests of all New Zealanders, not just Māori, isn't it?
This principle, yes, is about all the rights for all New Zealanders.
Which the treaty, as you acknowledge, doesn't speak to.
Yeah, well, that goes back to our opening kind of advice about it, this approach being a novel reading of the treaty, based on a novel reading of the treaty and existing jurisprudence and principles.
Yes, thank you. Well, that's all I had as far as my questions are concerned. I look forward to seeing your written replies to some of the points we've raised with you. And we thank you again for your important assistance for this inquiry.
Judge, sorry, I did have one question I forgot to ask.
Yes.
Is it all right if I ask it? Or
Yes, no, of course it's all right.
Thank you. Sorry, Mr. Chana, this is just based on one of your answers earlier where you referred to the work that the Ministry of Justice is doing with Māori in terms of adoption and other legal matters. So if the bill is enacted, there is no principle of partnership in it. Partnership can't be derived, I don't think, from the principles as they are in the bill. So in terms of the Ministry of Justice and the other government departments, if they continue, is there going to be two sets of treaty principles is my question. There'll be this set of principles in the bill, which have to be used whenever any legislation is being interpreted. But the government itself, ministries like the Ministry of Justice, when they work with Māori, are they going to continue working with Māori in partnership? Are they going to continue exercising active protection in the work of government, which will result in there being two sets of principles? Or is the whole of government going to shift to working only through what the bill says when it becomes an act, even though it only says that its extent applies to all legislation?
So if the bill were to be enacted and the provisions come into force, these would be the principles that would need to be used to interpret legislation, and through that, ultimately, we'd suspect it also underpins a lot of the decision-making that government officials would need to make. So that would be the statement in the law. But then the policy is also that it doesn't affect the text of the treaty itself. So here I'd be sort of just... This is generalising a little bit and sort of looking into the future with a big hypothetical, is that I would still see that we would continue to work with Māori on policy issues that are of relevance and interest, and that would be something we would continue to do. But then that would be coloured by the fact that with our comments around how our relationship with Māori might be affected having gone through this process and ending up with the principles should they be enacted. So I think it's probably a nuanced and complicated environment that would need to grapple with at that point should it become law. But I would still see that departments would need to continue to work with Māori on various issues that are relevant to their portfolios.
Yes, but do you see the point I'm suggesting is that there will be two sets of principles, because the Crown, in terms of government departments and ministers, will still be required in developing legislation and developing policy to act consistently with the principles of the treaty as they are now. And the scope of the bill only applies to legislation and legislation once it's enacted. So the uncertainty won't only be while the bill is bedded in and the courts wrestle with what it means, but also because there'll be two sets of principles. You'll still be working as officials, and ministers will still be required to work to act consistently with the treaty in their policy work. Am I correct in thinking that? Or will in fact the effect of the bill be much wider than legislation, and you'll feel compelled as officials to work to those principles?
Oh, I suppose at a high level, you're probably exploring what we captured in a couple of paragraphs, saying that it would create some uncertainty. There'd be uncertainty created. We have 40 years of jurisprudence and findings that have developed, and that's how we operate, and it's captured in cabinet circulars and other sort of documents that guide us. Should the bill be enacted, the issues that you're exploring would be things that we'd have to grapple with explicitly as opposed to only hypothetically now, and whether that's then tackled with through revised cabinet manuals or cabinet office circulars, I don't know exactly how we'd sort of try and reconcile that, but we'd have to engage in a process by which we kind of come to a conclusion on that.
Yes, so it could be that there will be two sets of principles, or it could be that in fact the effect of the application of the bill will be much wider than just legislation. We don't know yet what the outcome would be.
I mean, that is the case with different legislation, that it has a particular and specific application, but then it always influences and affects other things that are related to it.
Yes. Okay. Thank you, Mr. Chana. Thank you, Judge.
Follow-up question. So there's been a cabinet circular that received a lot of media attention last week about delivering services by need, not race. Has that gone through a treaty review process to see whether that circular was consistent with the treaty or the principles of the treaty? Because it came out of Cabinet, I presume that the Cabinet manual dictated the approach to its production.
I'm not familiar. I'm not familiar or aware of the process by which it was finalised.
Have you seen the circular?
Seen the circular.
All right. Can you produce that for us? Thanks.
Yes, we can provide that.
Thank you. Because is the circular an example of all government agencies being forced down a particular road away from acting in a treaty-compliant, consistent manner?
No, I'm not sure. I'm not in a position to sort of provide you with an answer at this stage. I'm aware of the circular, but I haven't engaged with it in any depth.
All right. Well, have a look at it, and if you feel that you can comment on it in the context of this inquiry, because remember, we're looking at a bill that's going to significantly change the constitutional landscape of both the legislative landscape and the public service landscape. Because your act will be effective, won't it? Public Service Act.
Sorry,
the Public Service Act?
The Public Service Act, yes.
So
that would likely be.
Yes. So I'd be interested in your view. If you could provide it.
Judge, if you carry that further, Judge, so kohanga reo, kura kaupapa Māori, all of those things could disappear because there's no obligation, there's no requirement for the government to continue to foster those. There's a whole raft of things like that that could be affected.
Right. Well, thank you. I think that's made the point enough for Mr. Chana to go away and think about it. If you can't comment on it, don't. But I would like the circular. I mean, we could probably get it off the Cabinet website anyway, but I'd like you to produce it. Thanks.
We can do that.
Well, thank you, everybody. That brings us to the end. Mr. Allen, was there any redirect?
No, thank you, Mum.
Any questions from anyone else? No? Well, that's brought us to the end of today.
Ms. Sykes here, is there going to be a transcript? I heard that magical word. So if there is, are we going to get it soon? Because that would certainly help us save some time.
Yes, I'm going to ask for urgency on the transcript. We have to have it quickly. How long do you think it'll take? Does anyone know? Even me? So it'll be 3 days, 4 days. Excluding the weekend, anything between 3 and 4 days? If it's dealt with by urgency, which it's going to be dealt with. Well, thank you, everyone. That brings us to the end of today. I'm going to ask Dr. Monty Suter to close us for this occasion.
Kāti, ko tinei te wahanga ki a mātou. Nā reira kei te mihati ki o koutou ngā kai kōrero i te rerangi. Me te hungoroia, te taha ki te krauna, te taha ki ngā kai kreme, kei te mihi atu ki ngā kai kreme, me ngā tangata katoa e whakarongo mai nā. Hei whakakapi i tēnei wahanga a tēnei wiwinga me ino i tātou. E te ariki anei mātou au pununga, e whakamuimiti ana ki a koe, nā i manaki mai nei a mātou i tēnei rā, tūkuna mātou ki a hoki pai atu ki o mātou kāinga. Whakamaharatia anotia ki a mātou ngā iwi o Aotearoa nei e te ariki no te whare ko tahi mātou. Me te kupu a tau tama, kei runga i ngā kareipiture, ki te tauhuri, ki ai anō te tai whare, kore tau a whare e tū. Nā reira e te ariki ki a tau, ki a mātou katoa, tau atu whai, me tau aroha, me te whiwhinga taitanga, ki tau wairua tapu, ake, 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 āmene.
Āmene.
footwear to skincare, hotels to headphones. Head to myboost.co.nz to reward your team.
Hey, it's Maddie and PJ, and we're away on holiday, but don't forget you can catch up with our podcast on iHeartRadio and follow along with our socials at The Hits Drive on Instagram.
But when we come back, we might need to do a high-level supercharged stakeout. We're going to fill you in on all the details next week.
We'll catch you from Monday on The Hits.
The club isn't the best place to find the lovers, so the bar is where I go. Me and my friends at the table doing shots, tripping fast, and then we talk slow. Come over and start up a conversation with just me, and trust me, I'll give it a chance. Now take my hand, stop it, and the man on the jukebox, and then we start to dance. And now I'm singing like, girl, you know I want your love. Your love was handmade for somebody like me. Come on now, follow my lead. I may be crazy, don't mind me. Say, boy, let's not talk too much. Grab on my waist and put that body on me. Come on now, follow my lead. Come on now, follow my lead. I'm in love with the shape of you. We push and pull like a magnet do. Although my heart is falling too. I'm in love with your body. Last night you were in my room, and now my bedsheets smell like you. Every day discovering something brand new.